Good evening. How are you, sir? Good to see you.
One-way lane traffic. All right. Hi, nice to see you.
Good to see you.
All right, sir.
How's it going? All good?
Let's put eyes on so I can actually
There
see.
you go.
Cross-eyed. Love letter. For my industrial Louis tool.
Mm-hmm.
For my industrial
I've
Louis
never
tool.
seen anything like that before, I gotta say.
It's a good.
Never. It's beautiful. Really pretty. No, she will not.
Oh, nothing. 0. 3 boxes. I figured there'd be a few. Well, I can't do that. That's salad and some pork.
You guys ready to start? Ready here. All right. Good evening, everyone. We'll call this meeting to order. We'll start with the invocation. Let's have a brief moment of silence, and then we'll stand for the pledge to the flag. All right, thank you. Please stand. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Thank you. And I have just a couple of housekeeping items. Please silence your cell phones. And something new we're going to be doing, please do not stand in the breezeway and have conversations back there. If you're going to have conversations, please take them out into the lobby so that they're not distracting for all the parties. And I'll move to approval of the agenda.
I move approval of the agenda as published. Second.
It's been moved and seconded. Is there any public comment on the agenda? Having seen none, all in favor, please say aye. Aye.
Aye.
Old business. I don't believe we have any old business. New business, approve the meeting minutes from March 10th, 2026. And there's an item on here from March 11th, 2025.
Mr. Chair, I think that document is just saved under the improper date.
Ah,
The document itself says approved meeting minutes March 10th, 2026. So I think we can overlook that, but I guess we need to get confirmation of that.
is this the meeting from April 21st, 2026? That's today.
That's today. The meeting minutes are correct. I think the agenda item, the title is wrong, but if that's just a matter of Scribner's error, I don't know. Do we need legal advice on that to move forward, or?
Okay, thank you.
I've reviewed the minutes and I move to approve them as written.
Second.
It's been moved and second. Is there any public comment on the minutes? Having seen none, all in favor, please say aye.
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 Okay, before we move to item B, would you like to give us the briefing on the affected parties, or do you want to do that later?
Thank you, Mr. Chair. For those in the audience who don't know me, I'm Patrice Boyes. I'm special counsel to the City of Alachua for land use matters, and we've got a number of quasi-judicial proceedings this evening, and we have some procedures we're going to follow so that we have an orderly, fair hearing for all the parties, the public, the applicant, etc. So I'm going to read from a brief memo that's been provided in the back of the room on the city website and to staff. Who is an affected party? Affected party is a label given for purposes of public notification when the type of application before the city of Alachua requires notice and a quasi-judicial public hearing on the application for development approval. The Land Development Code defines affected party as any person who will suffer an adverse effect to a property interest from the proposed application for development permit, including interests related to health and safety, densities and intensities, traffic congestion, environmental impacts, aesthetic impacts, and similar effects. Any person who has land adjacent to the land subject to the application for development permit. So that's in the city code. Now, what does this mean, and how do you know if you are an affected party? Here's a simple test for what you will need to demonstrate when you come forward to the podium and address the chair. First, if you have a property interest, for example, you own or lease property, or you have a contract to purchase property, and your property is adjacent to the land subject to an application for development approval, Or the application, this is the important part, the application for development approval, if granted, would pose an adverse effect to your property interest. So it's important to show that you are more directly affected than the public at large. Remember, if you don't qualify as an affected party, you nonetheless have the right to speak during public comment. So this is just, you have an enhanced ability to address the board or the city commission. For example, a citizen who lives 5 miles from the proposed project and cannot prove a direct impact may or may not be considered an affected party by the Planning and Zoning Board and or the City Commission. Please note that all requests for affected party status are granted or denied directly by the board or commission at the time of the public hearing. In the future, we're going to have a registration process, and I know this is going to take a little while to get this procedure rolled out and for everybody to get used to it, but it will protect everybody's rights. For now, you'll register, if you will. You'll offer yourself as a proposed affected party by coming to the podium this evening. If you are granted affected party status, you will have certain privileges at the public hearing, including additional time to present testimony. Note that that is not an unlimited amount of time, it is a reasonable amount of time, and it's subject to the chair's guidance as the hearing unfolds. And your request for affected party status will be based on the facts that you articulate the reasons why you believe you're an affected party when you come present yourself. You will have additional, like I said, additional time to present testimony subject to the chair's approval and the right to cross-examine witnesses and city staff. So there are procedures in the code for how the quasi-judicial hearing will be conducted. This process doesn't change any of that. It just helps us manage all of the inputs so we have a good solid record. And anyway, you must nonetheless adhere to those procedures for quasi-judicial hearings that are in your land development code. And like I said, if you're not granted affected party status, you can be a participant in the public comment period. All right, when you come forward this evening to present yourself as a proposed affected party, you must give your name, your address. If you are coming forward because you own property next to the proposed development site, if you know your tax parcel number, provide that. I don't expect that you would tonight. And then you would state your reasons for why you believe you're an affected party. So what happens at the public hearing? Like I said, we're going to follow the procedures for quasi-judicial hearings in section 2.3.1 of the city's land development code. And after the chair determines whether to grant or deny you affected party status using the tests that we've talked about, you should be prepared to answer any questions from the board, particularly the reason you believe you are more directly affected than the general public by the development application. If granted, the affected party has a reasonable opportunity to present testimony, including experts, and evidence in support of or in opposition to the application, and to ask questions of the applicant, the applicant's representatives, and city staff. This evidence may include documents, electronic files like videos, provided in the future you'll have to submit these items ahead of time so that all parties have an opportunity to look at your materials and you can look at their materials and then come fully prepared to the hearing. Understand that if you are an affected party, you may be subject to cross-examination by the applicant and city staff. An affected party may cross-examine city witnesses, the land development administrator, city staff, and the applicant. Notice, and this is going to be a little different. I know you will be on a learning curve about this, but it's not an unfettered right for you to testify while you're cross-examining a witness. In other words, if you're asking a question of the witness and they give you an answer, it's not proper for you to turn to the board and give your opinion or editorialize about that answer. You're there to ask questions. And so you're going to hear the chair stop that behavior if it happens tonight and ask if you have any more questions for that witness. It's also not an opportunity to offer new material. So cross-examination is you're asking questions about what that person just testified about. You should aim for about 5 minutes of cross-examination questions, and that is up to the chair's discretion to give you additional time. The same rule of thumb will apply if you offer rebuttal testimony to support your position on the development application. That is not the time to raise new material. It's not fair to the other parties or to this board. It's a time for you to counter what the witnesses on the other side of your position have said. And you should, again, aim for about 5 minutes of rebuttal. Let's see here. Know that quasi-judicial hearings, you've heard me say this before, are not governed by strict rules of evidence like a courtroom, but nonetheless, the chair this evening may exercise their discretion to apply some of those rules of evidence to exclude testimony or evidence that is determined by him to be irrelevant, frivolous, immaterial, inflammatory, unreliable, unduly repetitious, or otherwise out of order. The goal is to have an orderly civil hearing at which all parties, including the applicant, affected parties, and the public, have a full and fair opportunity to be heard. If you have questions as we go forward, please don't hesitate to ask. So we're here to help you adduce your testimony and evidence this evening, but we also have to be fair to the other parties and the applicant. Thank you, Mr. Chair.
Thank you, Madam Attorney. All right, let's proceed with item B, please. Go ahead, sir.
All right. Good evening, Chair, board members, planning director, and city attorney. My name is Parker A.H. Stevens, planner with the City of Alachua Planning and Community Development Department. My resume is on file with the Office of the Deputy City Clerk. Do we need to be sworn in?
This is quasi-judicial. Anyone wishing to speak on this matter, please stand.
Do you swear or affirm the testimony you're about to give is the truth and nothing but the truth?
I do,
Thank you.
and I have been sworn in. Item B under new business is a quasi-judicial item, application number PCA 2601. The item is a request by Sheila Spence, applicant and property owner, for a certificate of appropriateness for an additional structure in the City of Alachua Downtown Historic District. The approximately 0.13 acre subject property is located at 14722 Northwest 140th Street, tax parcel 03663001001. As provided for in Section 2.1 of the City Land Development Regulations, the applicant shall have the opportunity to present first, followed by affected parties, and lastly, the presentation by staff.
Go ahead.
Good evening again, board members. Parker A.H. Stevens for the record. Again, this item is a request by Sheila Spence, applicant and property owner, for a certificate of appropriateness for the addition of a carport to a structure in the City of Alachua Downtown Historic District. The proposed alterations include an additional subject property for carport. Here we have an overview of the subject property, shown in the black and white hatched border, with north being the top of the map. For reference, Main Street runs north to south, and the Alachua Chamber building is located generally to the west of the property. The Alachua, the City of Alachua Downtown Historic District is established in Section 3.7.2 of the city's land development regulations, with its general purposes being to protect the beauty of the city and improve the quality of its environment, protect designated land and buildings or structures having historic or architectural significance, stabilize and improve property values, foster civic pride, and encourage redevelopment of the city's downtown. Here we have an overview of the historic district in the yellow area, with contributing structures noted in the light blue color. The subject property is located within the black and white hatch border. These images submitted by the applicant show the existing structure, which is not a contributing building to the historic district. The first image here shows the proposed design of the addition, and the second image shows the proposed location. The application has been reviewed for consistency with the City of Alachua Comprehensive Plan. Specific goals, objectives, and policies that support the application are located in the future land use element, and a full evaluation of consistency with specific goals, objectives, and policies is available in the staff report. Section 2.4.6F of the city's land development regulations establishes the standards with which all certificate of appropriateness applications must be found compliant, listed here on the screen. The application has been reviewed for the compliance with the standards of Section 2.4.6F, with the findings available in the staff report, but I will now briefly go over each standard. Firstly, affecting exterior appearance. The proposed addition of an additional structure to the structure located at 14722 Northwest 140th Street is not a contributing structure. The addition will be visible from the street and will not affect the appearance of historic buildings or structures listed on the National Register of Historic Places or the City of Alachua Downtown Historic District. Effect consistent with historical, architectural, or other relevant qualities. The proposed addition of a carport will preserve the architectural character of the district. The design of the carport is complementary in nature to the existing structure and will keep with the architectural qualities of the historic district. Negative or positive impact on neighboring properties of historic significance. There are 4 contributing properties located proximate to the subject property. The applicant has provided photographs of the approximate structures to demonstrate the compatibility of the proposed structure with the surrounding historic district and contributing structures. The proposed addition will not negatively impact the neighboring properties that have historic significance. Effective denial. The proposed addition provides a practical, functional improvement without altering the historic character of the surrounding properties. Denial would limit the property's reasonable and beneficial use. Demolition. No demolition is proposed. Therefore, the standard is not applicable. Staff recommends that the Planning and Zoning Board approve the Certificate of Appropriateness for Shelia Spence. And at this time, I am able to answer any questions the board might have regarding this presentation.
Any questions from the board?
Mr. Chair, before we go any further, if we can determine if any of the board members have any ex parte communications, starting with Ms.
No. None.
No, sir.
No. Does the applicant wish to speak?
This could be completely unrelated, but it is a question. I've received at least 3 emails, and I think they're more related to a spam situation where it's requesting that I pay between $4,150 and $4,500, for the sundry fees associated with this carport. I'm guessing this is a scam of some sort, so I just wanted to bring that up.
Mr. Chair, the applicant is correct. There is a scam going around. It's actually nationwide where basically the scammers are going in, looking up the agendas on local governments' websites, and then sending out notices, using fake letterhead and things like that. So
Yeah, I mean they were very, very accurate. They described the property to a T. I'm glad that I'm not glad it's a scam, but I'm glad you're not looking for an extra $4,500. So,
just,
I-
just for the record, the city will never ask you to wire money or anybody to wire money
that's
for an
what tipped us
application
off
fee.
for sure. So, but I've received at least 3, and there's 2 more in my mailbox to just give you guys a heads up. All right, thank you.
Thank you. Is there any public comment on this item? Having seen none, members, can I have a motion, please?
Mr. Chair, I move that based on competent and substantial evidence presented at this hearing, the presentation before this board, and staff's recommendation, this board finds the application for Sheila Spence to be consistent with the City of Alachua Comprehensive Plan and in compliance with the city's land development regulations, and approve the certificate of appropriateness application.
Second.
It's been moved and seconded. This will be a roll call vote. Ms. Highlander?
Aye.
Ms. Judd?
Aye.
Mr. Minidier?
Aye.
And the chair votes aye. This item passes. Next item, item C. Could we have everyone that wishes to speak on this matter, please stand so we can swear you in?
Do you swear affirm the testimony you're about to give is the truth and nothing but the truth?
I do.
Good, Mr. Attorney.
And same thing, any ex parte communications on this matter?
No. None.
No.
No.
Thank you.
Alrighty. Good evening, Chair, Vice Chair, board members, city attorneys, City Planning Director, Carson J. Crockett, Principal Planner for the City of Alachua. My resume is on file in the Office of the Deputy City Clerk, and I've been sworn in. This hearing is a quasi-judicial hearing, application number PSP 25-0014, known as the San Velasco Tech City Fire Station Site Plan Application. The item is a request by NV5 Incorporated as the applicant and agent on behalf of the Laser Investment Group LLC, the property owner, for proposing the construction of an approximately 11,300 square foot fire and EMS station with associated site improvements. As provided for in the city's LDRs, the applicant will have the opportunity to present first. Staff has not received any notice of any affected parties, but if they are present, and then lastly, the presentation by staff.
Randy Olney of NV5, address is 11801 Research Drive, Alachua, Florida. Just here to say that we are in agreement with staff's conditions for approval and here to address any questions the board might have.
Does the board have any questions at this time? All right. Thank you.
Let's get on with it then, shall we? Good evening again, Board. Carson J. Crockett for the record. As previously stated, this fire station would be located on approximately 1.03 acre subject property, approximately 11,300 square feet of floor area, with associated site improvements, generally located on Northwest 86th Drive, north of US Highway 441, and south of Northwest 87th Court. There would be one ingress and egress point to the rear of the property. That would be the main ingress and egress, and then the emergency egress for the fire trucks would be located directly on Northwest 86th Drive. Stormwater would be conveyed to an existing stormwater management facility. Here we have an overview of the subject property in the black and white hatched border. It's a little small there. My apologies. For reference, north is the top of the map. 441 runs along the southern side here. Tech City in its major development area is off to the west a bit. The Phoenix Commercial Park is south, with Northwest 86th Drive coming through that commercial park and fronting the property there. The egress would mainly be through that back corner, and then the stormwater management facility is located approximately there, north of the site. Here we have that site plan. The map's been rotated slightly, so north is now kind of up in the top right corner. This, for reference, is that stormwater management facility that's pre-existing. This would be Northwest 86th Drive along the front. This is the fire truck bays with the egress going out to Northwest 86th, and then the private drive coming down into here where the parking is located in the rear. A neighborhood meeting was held to discuss the application on December 8th, 2025. Materials submitted by the applicant indicate that the meeting was attended by one member of the public. A neighborhood meeting summary is available for your review in the application materials. The application has been reviewed for consistency with the comprehensive plan. Specific goals, objectives, and policies that support the application are located in the future land use, transportation, and the community facilities elements, with a full evaluation available in the staff report. Staff found the application to be consistent with the comprehensive plan. An environmental conditions analysis was conducted for all these environmental features listed here on the screen. Staff noted no concerns related to these environmental features. A full analysis is available in the staff report. Section 2.4.9E1 of the city's land development regulations establishes the standards with which all site plans must be found compliant. A full evaluation is available in the staff report, but I'll briefly go through each of these listed here on the screen in this presentation, if the clicker decides to keep working. Number one, consistent with comprehensive plan. We just went over that. Staff found it to be consistent with the comprehensive plan. That full evaluation is again in the staff report. Use allowed in zone district. Fire and EMS use types are permitted in the corporate park zone district by table 4.1-1. Use-specific standards. The application was reviewed for and found to comply with the use-specific standards for the type of fire and EMS. Those are established in section 4.3.2G of the city's land development regulations. Development and design standards. The application was reviewed for and found to comply with all relevant and applicable standards in Article 6 of the city's land development regulations. Subdivision standards. No subdivision of property is proposed, therefore the standard is not applicable. Complies with all other relevant laws, ordinances, etc. The application has been reviewed for and found to comply with all other relevant city ordinances and regulations. Staff conducted a public facilities impact analysis and determined the anticipated impacts from the application would not degrade the level of service of any facility monitored for concurrency. That full evaluation is available in the staff report. A site plan is a final development order, and if approved, concurrency will be reserved. That brings us to staff's recommendation, which is that the Planning and Zoning Board approve the site plan for the Laser Investment Group, LLC, subject to the 7 conditions provided in Exhibit A and located on page 21 of the April 21st, 2026 staff report to the Planning and Zoning Board. This concludes staff's presentation. I'm available to answer any questions the board may have.
Is there any questions from the board? Public comments, please.
Is there anyone at this point that wishes to be designated as an affected party, given the definition that Ms. Boyce had originally said in this meeting? Seeing none, go ahead.
Thank you, Mr. Chair, board members. So first of all, I'd like to ask that the staff put on the overhead the conditions so that we all can see what those conditions are, and you can know that if you're going to approve this site plan, that you know exactly what the conditions are. I think that's proper evidence. I also would like to know where first of all, I don't agree with the fact that a public facility such as this fire station is located on a private development inside of a private development utilizing a private road. I think it's a public facility. It should be publicly viewable, easy to locate, and should be within easy location. Anybody driving down 441 should see that there's a fire station. Like somebody's driving, they have a child in the back that's choking and they want to get to the paramedic. Oops, there's a fire station, pull over. How are they going to know there's a fire station back there? Off-site signage is prohibited in the city of Alachua. So a specific sign identifying this public facility is not going to be able to have a sign on 441, how is the public going to know there's a fire station back there? So unless there's some sort of exception to the sign allowance that provides for an off-site signage to be located on 441. So I just think this was a bad idea right out of the gate. I understand that Tech City donated the property for this public facility, and to take it off of the main state highway and put it back inside of a private development, I think flies in the face of what a public facility is intended to do. So thank you.
Thank you. Any other public comment? Having seen none. Members, any comments?
Mr. Chair, I had a few, if I may. Kind of jumping ahead, I did look forward and looked at the comments on the fire flow, which obviously that's not something under the purview of this board per se, but it would come at the time of building permits, so on and so forth. I think I read somewhere that there wasn't a confirmation that there would be, and I'm going to say it in layman's terms on the fire flow calcs, that there would be enough you know what I'm saying, when a fire needed to occur, that would be there. So I know that's not at our level at this point, but I did pick that up somewhere. And then my general question was, I thought it was Alachua County Fire Rescue. I don't know if it's station number 25, which is, not immediately adjacent, but very close to. So I was trying to figure out how this station was going to coordinate with the county station in terms of a level service, response time. Was the thought that this would always be a private station? Perhaps was this something that was in the planning stage before the county did the additional site? So I have a coordination question, which I think would be under the purview of the applicant. And then I would ask if they could confirm my understanding of the fire flow that was contained within the staff report. Thank you, Mr. Chair.
Thank you. Would the applicant like to come forward and speak to this?
Hey, Mr. Chair, Randy on again with MV5. As far as the fire flow tests that were performed out on the site, yes, they were just slightly below what is required. However, during a building permit review, a fire protection engineer should be able to design a system with pumps that can overcome that and still provide the available fire flow that would be needed for the building through the sprinkler system. And then the other one, as far as the other fire station, I wasn't sure which other, the one off of 441 there.
Mr. Chair, yeah, it's in my mind, you know what I'm saying, as you're driving, it's kind of there, and then you got the tech center. So how is all this going to fold and coordinate, work together?
My understanding from the county is that they are going to replace that existing fire station with this one.
Okay, so Mr. Chair, that brings a follow-up question. So now we're going to have in essence, part of under the umbrella of Alachua County Fire Rescue, not accessing off of a major arterial highway. Is that correct?
It will access the internal roads and work to 441.
Okay.
Yep.
Again, I know that's not under the purview of this board, and it's something under the umbrella of the county. I don't recall what their requirements were, but I could have sworn there was something that when they have a fire station, you know what I'm saying, it needs to be on a major arterial road. That's not for us to decide, but I would just say I think it's great, you know what I'm saying, that the San Velasco Tech folks, stepped up to the plate and assisted. But I'm wondering about the design and the location of this station. And I don't know who will still own the land that the fire station, I guess, that they're going to abandon or whatever. I don't know. It seems to me maybe there could be an exchange there or something. I don't know. But excuse me, I do have concerns. It just doesn't seem to me like the logistics, not the short term, but the long term, were fully thought through under the process. And again, this is no criticism of the owners at the tech center. I think it's great that they've done this. You know what I'm saying? I think it shows their civic involvement. But so the county has signed off on this. Is that what I'm hearing tonight?
That is my understanding, yes.
In writing?
I'd have to ask the county on that one.
Okay, I'm looking to the Mr. Sergio in the back, I guess, or okay.
Not an easy question, but an interesting one nonetheless.
Sergio Reyes, CDA Consultants. I'm not the applicant for this application, but I can explain a little bit what happened. Number one, this is a county fire station. It's not a private station. The land will be county land, and it has access through a county public road. 86 Drive is a city of Alachua road. It's public road. They directed access to 441. And fire station is current along 441 and Phoenix Park, all Phoenix. That is gonna be removed to be replaced with this new fire station.
Okay, so through the chair, so the footprint for the new fire station will not be at the location of the old one, correct?
That's correct.
Okay, all right. But the county will still own the land that the current station is located on.
No, the current lift station is a lease. The county
Oh, a
lease
lease.
that
Okay,
piece of
all
land.
right.
It's a
Okay,
temporary station. And you see the reason there is a mobile home there or manufacturing home is because it's temporary.
got it. Okay, thank you very much. I appreciate it.
Thank
Do you have any further comments?
Yes, sir, Mr. Chair.
Anything else from the board? Okay, may I have a motion, please?
Is it possible to see the 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 conditions? Yeah. Is that a yes or no? Can we see the conditions?
Carson, if you would, please put that.
Yes, Mr. Chair, and I can also read them into the record if you would like. There we go. If I have the lights, please. These are also found in Exhibit A of the staff report, which is on page 21 of the staff report. Condition 1. The applicant acknowledges and agrees that if any gopher tortoises or gopher tortoise burrows are discovered on site, it shall provide a 100% gopher tortoise survey for the subject property, which shall include a list of all local, state, and federal permits required for relocation of any gopher tortoises on site. Survey shall be valid for a period of 3 years from original date of survey. This condition shall be the obligation of any subsequent party with interest in the property subject to this development order. Condition number 2. The applicant acknowledges and agrees that if any killdeer or killdeer nests are discovered on site, it shall provide a 100% killdeer survey for the subject property. Survey shall be Survey shall be valid for a period of 3 years from original date of survey. This condition shall be the obligation of any subsequent party with interest in the property subject to this development order. Condition 3. The applicant acknowledges and agrees that it shall utilize the standard measures for protection of the eastern indigo snake as outlined in the latest snake protection education plan developed by the U.S. Fish and Wildlife Service. This condition shall be the obligation of any subsequent party with interest in the property subject to this development order. Condition 4. The applicant acknowledges and agrees that all public access and utility easements shall be prepared in coordination with the city's Compliance and Risk Management Department and shall receive approval of the city's Compliance and Risk Management Director prior to being recorded in the public records of Alachua County and prior to the issuance of a building permit for any building activity associated with this development order. The applicant shall incur all costs associated with preparing and recording easements. This condition shall be the obligation of any subsequent party with interest in the property subject to this development order. Condition 5. The applicant acknowledges and agrees to ensure sufficient fire flow compliant with any regulations from the authority having jurisdiction (AHJ) prior to the issuance of a building permit. The applicant shall be responsible for any cost associated with the provision of adequate fire flow. This condition shall be the obligation of any subsequent party with interest in the property subject to this development order. Condition 6. The applicant acknowledges and agrees that it shall obtain all other applicable local, state, and federal permits before the commencement of site plan work. This condition shall be the obligation of any subsequent party with interest in the property subject to this development order. Lastly, Condition 7. The applicant acknowledges and agrees that conditions 1 through 6 as stated above do not inordinately burden the land and shall be binding upon the property owner, including any subsequent property owners, successors, or signs, and that the site plan shall comply with conditions 1 through 7 as stated herein. And as we've already heard, the applicant agreed.
Thank you.
Mr. Chair, I'll move based on competent substantial evidence presented at this hearing, the presentation before this board and staff's recommendation, this board finds the application for the Laser Investment Group LLC to be consistent with the City of Alachua Comprehensive Plan and in compliance with the city's land development regulations, and approve the site plan subject to the 7 conditions provided in Exhibit A and located on page 21 of the April 21st, 2026 staff report to the Planning and Zoning Board.
Second.
It's been moved and seconded. This will be a roll call vote. Member Highlander,
Aye.
Member Judd,
Aye.
Member Menadier. Sorry.
Aye.
And the chair votes aye. The motion passes. Thank you.
Thank you, Board.
All right. Item D.
Good evening again, Chair, Board members, Planning Director, and City Attorney. Parker A. Stevens, planner with the City of Alachua, Planning and Community Development Department. My resume is on file with the Deputy City Clerk. And I would ask that we all the applicants be sworn in.
Anyone wishing to speak on this, please stand to be sworn in.
Do you swear or affirm the testimony you're about to give is truth and nothing but the truth?
Mr. Attorney.
Any ex parte communications, please?
No.
No.
No, sir.
No.
Thank you. All right. Item D under new business is a quasi-judicial item, application number PSP 2511. The item is a request submitted by Paulson Mitchell Wise on behalf of the property owner, Alachua 441-235 LLC, for a site plan proposing an approximately 3,600, square foot car wash with drive-through service and associated site improvements on an approximately 1.25 acre subject property, generally located at the southeast corner of U.S. Highway 441 and Northwest 173rd Street. As provided for in Section 2.3 of the city's land development regulations, the applicant shall have the opportunity to present first, followed by affected parties, and lastly, the presentation by staff.
Good afternoon. My name is Alex Perry, 1141 Dixon Road, Roberta, Georgia. I'm the engineering design manager for Tidal Wave Auto Spa, and we're excited about the opportunity to come be a part of the community. I know staff has done an extensive report on all the aspects of the project, so I'm here and happy to answer any questions.
Thank you. Oh, I'm sorry. Is there anyone who wishes to claim affected party status? Having seen none.
Good evening again, Chair. Parker A.H. Stevens, planner of the City of Alachua, for the record. This item is a request submitted by Paulson Mitchell Wise on behalf of the property owner, Alachua 441-235 LLC, for a site plan for approximately 3,600 square foot car wash with a drive-through service, associated site improvements on an approximately 1.25 acre subject property, generally located at the southeast corner of U.S. Highway 441 and Northwest 137 Street. There are 2 ingress and egress are proposed on Northwest 161st Place, and cross access is connected to the properties to the east and the west. Stormwater runoff is proposed to be directed to an off-site management facility that is part of the Santa Fe Crossings infrastructure plan. Here we have an overview of the site project shown in the black and white hatched order, with north being the top of the map. Northwest 173rd Street runs north to south here, and US 441 runs east to west. Here is an overview of the proposed site plan. For reference, US 441 is located here along the west boundary, and 173rd is located up beyond this location up here. Here are the two ingress and egress points located on 163rd Northwest Place. Associated parking for the location is located here along the east. Additionally, here is a cross-section connecting the existing Chick-fil-A property located here and the Firestone located over here. Stormwater management facilities are located off-site. A neighborhood meeting was held on July 31st, 2025 at 16367 Northwest 167th Boulevard, the Holiday Inn Express and Suites. As required by Section 2.2.4 of the city's land development regulations, all property owners within 400 feet of the subject property were notified, and notice of the meeting was published in a newspaper of general circulation. Materials submitted by the applicant indicate that the meeting was attended by one member of the public, and a neighborhood meeting summary submitted by the applicant is available for review in the application materials. The application has been reviewed for consistency with the city's comprehensive plan. Specific goals, objectives, and policies that the application are consistent with can be found in the future land use, transportation, community facilities, and conservation and open space elements. A full evaluation of specific goals, objectives, and policies are included in the full staff report. An environmental conditions analysis was conducted, and the findings are included in the staff report. There are no concerns with the environmental features listed here on the screen. Section 2.4.9E1 of the city's land development regulations establishes the standards of which all site plans must be found compliant. These standards are listed here on the screen, and an evaluation of the application's compliance with these standards is included in the full staff report. I will now briefly go through each of these standards. Consistency with the comprehensive plan. An evaluation of the application's consistency with the comprehensive plan is included in the staff report. Staff has found the application to be consistent with the City of Alachua's comprehensive plan. Use allowed in zone district. The use type of car wash is a permitted use in the commercial intensive quotation CI and quotation zone district as located in table 4.1.1. Zone district use specific standards. Use specific standards for car wash are established in section 4.3.4 J5 of the city's land development regulations. The application has been reviewed against and found to comply with the use specific standards. Development and design standards. The application has been reviewed for compliance with all applicable and relevant standards of Article 6. Subdivision standards. No subdivision of land is proposed as part of this application, therefore the standard is not applicable. Complies with all other relevant city laws, ordinances, regulations, requirements, and state and federal laws and regulations. The application has been reviewed against Section 6.8.2, Design Standards of Business Uses, and with all the findings included in the staff report. The application complies with all other relevant city laws, ordinances, regulations, requirements, and state and federal laws and regulations. The proposed site plan was reviewed with compliance for Section 6.8.2 of the city's land development regulations, which establish design standards for business uses. The application has been reviewed for and found to comply with the standards listed here on the screen. A full evaluation of compliance with Section 6.8.2 is included in the staff report. Public facilities impact analysis was conducted for the application, and the findings are included in the staff report. The application was reviewed for concurrency with the items listed here on the screen. The application will not result in an adverse impact to level service of any public facility, and the impacts are therefore acceptable. A site plan is a final development order, and concurrency will be reserved. Staff recommends that the Planning and Zoning Board find the site plan application for Alachua 441-235 LLC to be consistent with the City of Alachua Comprehensive Plan and in compliance with the City of Alachua Land Development Regulations, and approve the site plan subject to the 3 conditions found in Exhibit A and located on page 26 of the April 21st, 2026 staff report. At this time, I'm able to answer any questions the board might have regarding this presentation, and I also have the conditions available for review if there are any questions regarding a specific condition.
Thank you. Board, do you have any questions? No? All right. At this time, we'll take public comment.
Hello, Mr. Chair, Soria Lindberg. I was the only person at the neighborhood meeting for this. Very nice applicant to speak to. Thank you, staff, for your presentation. I just want to note that when at the neighborhood meeting, and the applicant can correct me if I'm wrong, I learned they're going to use 20,000 gallons of water a day, which is going to be on city water, which staff confirmed with me this week. And based on city standards, when we do residences, we say it's about 250 gallons a day. So I just want to put it in perspective. That's about 100 houses a day worth of water. I know that is not a deal breaker. I also have a lot to learn, and it's confusing why these site plans come if it's already a use for this area. But just feedback from the community, it's a little silly to have 3 car washes in 2 miles. But I don't know if we're catering to the interstate or the 11,000 or so people who live here. And when I see the water concurrency that's available on the city website, it's only water concurrency for residential. I don't have access, I don't know if you do, or if that's something I can request, is water concurrency for commercial development. So when we see that the public facility impact will not be affected, I don't know what those numbers are, because we learned recently that the city water concurrency for residential is about 1.56 million gallons of water per day, and their permit is 1.78. But the city likes to go off their capacity based on their pumping, if I understand correctly. So residential, we're very, very close, not knowing what the commercial is. So that's just a question that I have being on the outside. And I'm also confused, Mr. Chair, that this was not on the agenda for quasi-judicial, so I don't know why we're doing quasi-judicial here. It's a little confusing to the public, because if someone did want to prepare, it'd be helpful. So those are my comments that I was just thinking of about this. So thank you very much.
Thank you. Members, any questions?
I don't know if it's so much a question, but kind of to that point, I was curious, not to impact this application necessarily, but does the city look at any data on small business and provide that information to businesses coming in? Or, other municipalities have methods to, for lack of a better word, limit the number of businesses if we get to a point, is that something the city's considered? Or maybe not a question for tonight, but just, as I was reading through, I was thinking of that.
Mr. Thomas.
Mr. Chair, I'd ask Principal Planner Carson Crockett to come forward. He prepares our concurrency report for the city on a monthly basis. That are able to answer that.
Mr. Chair, if I could just clarify the question, are you asking regarding the concurrency numbers, or are you asking regarding the location of a certain number of car washes in a vicinity?
That.
Okay. Yeah. So just to clarify, Mr. Chair, our zoning generally allows a whole broad list of uses. No one in the city is going, we're going to plop 3 car washes right there. That's more of a market-driven decision. based on the applicant, what they think they can do with their property, based off of our zoning code. So the zone district allows for it. That's kind of where that decision stops. They could theoretically line 5 in a row there. Not saying that would happen, but just to clarify that point.
Thank you. Does that help answer your question? Is there any further questions?
Mr. Chair, I was just going to add, I mean, it does beg the question. I was thinking the same thing when I saw this. In terms of a needs analysis, you know what I'm saying? I know like sometimes you get a plethora of what I call the storage units, you know what I'm saying? And they go and they do their market stuff and there's so many new houses, therefore it'll generate all these need for storage units and sure enough over time, but I don't know what the market answer is for car washes, but it does seem to be a bit much. Back to the concurrency question, can you walk through what Ms. Soria was talking about, the commercial, the residential, so that everybody understands and the public how that flows into your concurrency report? Thank you.
Absolutely, Mr. Chair. If I could actually borrow the concurrency report that one of you received today. Thank you. Just for general information, our annual concurrency status report was published on April 13th and is available on the city website for public viewing. As part of that process, we update what we call less actual potable water flows. So we have our general capacity, which is the current permitted capacity, and that current permitted capacity is based off of the pumping capacity permitted through the Florida Department of Environmental Protection, not the Swanee River Cup. That is a separate permit, and that's an average. This is an absolute capacity. So our absolute capacity is at approximately 3 million gallons per day pumping, less the actual potable water flows, which is at approximately 1.447 million gallons per day. That takes into account the actual numbers we are seeing drawn from our wellheads. So that accounts for everything that's hooked up to our potable water system. That includes irrigation, that includes residential, that includes commercial, industrial, the whole list. So that is taken into account in our concurrency.
Sorry, Mr. Chair, a follow-up on that, but the one thing it doesn't theoretically include is if you have your own, you know what I'm saying, consumptive use permit. You know what I'm saying? Like if you have a well, that it is not in our numbers. Is that correct?
Mr. Chair, that's correct, because this number is about what the city is allowed to pump and what the city can supply to its residents. If someone has their own well, they're not receiving city water supply.
Correct. Thank you.
Thank you. Any further questions? All right, I'll entertain a motion.
I move that based upon the competent substantial evidence, the presentation before this board and staff's recommendation, this board find the site plan application for Alachua 441235 LLC to be consistent with the City of Alachua Comprehensive Plan and in compliance with the City of Alachua Land Development Regulations, and approve the site plan subject to the 3 conditions found in Exhibit A and located on page 25 of the April 21st, 2026 staff report.
Second.
It's been moved and seconded. This is a roll call vote. Ms. Highlander?
Aye.
Ms. Judd?
Aye.
Mr. Minidier?
Aye.
Chair votes aye. Motion passes. Thank you.
Thank you, board.
Item E. Could we have everyone that wishes to speak stand to be sworn?
Do you swear or affirm the testimony you're about to give is the truth and nothing but the truth?
I do.
Ex parte communications, please.
None.
None.
No.
No.
Thank you, Mr. Chair. This item is PSP 25-0012. It's application by for Westside Commons Heartland Dental Site Plan Permit, a request by Alachua Acquisitions LLC, who is the applicant and agent on behalf of Alachua Outparcel LLC, and Santa Fe Hills Church of Christ Incorporated, the property owners, for a site plan proposing the construction of a 4,200 square foot dental clinic with associated site improvements on a 0.69 acre subject property generally located along the north side of U.S. Highway 441, just west of the intersection of U.S. Highway 441 and Northwest 173rd Street, also known as County Road 235A, on tax parcel 03044-001-002, a portion thereof, and 03044-002-000, also a portion thereof. As this is a quasi-judicial hearing for this item, the applicant has the opportunity to give presentation or comment, and then followed by affected parties, and then staff report.
Do we have anything from the applicant?
Yes, good afternoon. Chris Blurton with Interplan LLC, 220 East Central Parkway, Altamont Springs, Florida. I'm here to answer any questions that the board may have, or the public may have, or at least attempt to. We're proud to finally be standing here in front of you, looking at the approval of these site plans, hopefully, all three site plans at the West Side Crossings. Thank you.
Thank you. Is there anyone that wishes to ask for affected party status?
Hello, Mr. Chair. I believe I'm an affected party because I live within 400 feet of this property, and I got a letter about it as well.
And how do you perceive being affected any more than the general public?
My property is within, I can see it from my house, so I thought it was within 400 feet.
I understand, but
Yeah.
you are in a separate subdivision away from this
Oh,
property?
okay. The intersection to leave my neighborhood is the intersection of this development, and also there is an entrance and exit on 235A at 441 where everyone uses on that.
Right, but that's not inside your neighborhood, though, correct?
No, it's not. It's next to it. Mhm.
All right. Any questions from the board? At this time, I would deny your request for affected party. I don't see where you would be any different than the rest of the general public.
Okay, thank you.
Thank you. Please come back at general comments. Anyone else? Mr. Thomas.
Thank you, Mr. Chair. As stated, this is and I misstated there was a typo on the first page. It's actually a 1.28 acre subject property. Again, generally located at the northwest corner of US 441 and Northwest 173rd Street. The site plan proposes 2 ingress and egress points via shared driveways, one connecting to US Highway 441 and one connecting to Northwest 173rd Street. Stormwater is proposed to be directed to an off-site facility that's part of the West Side Commons Infrastructure Plan, which was approved on December 8th, 2026 by the City Commission. Here's a overhead aerial view of the subject property. As you can see, it kind of straddles the property line between two parcels. 441 to the south. Wrong clicker. 441 to the south and 173rd, one lot over to the east. And here's a general overview of the site plan itself. And so you have parking adjacent to 441 and then some additional parking in the rear along this internal access driveway, which basically circles the entirety of these 3 parcels. There was a neighborhood meeting conducted on October 21st of 2025 at the Legacy Park Multipurpose Center in meeting room number 2. as required by section 2.2.4 of the city's land development regulations. All property owners within 400 feet of the subject property were notified, and notice of the meeting was published in a newspaper of general circulation. The materials submitted by the applicant indicate that the meeting was attended by one member of the public. The application has been reviewed by staff for consistency with the city's comprehensive plan. The specific goals, objectives, and policies that the application are consistent with can be found in the following elements: future land use, transportation, community facilities, and conservation and open space. And a full evaluation of the specific goals, objectives, and policies is included in the staff report. An environmental conditions analysis was conducted on the parcel, and all of the elements of that analysis were found to be satisfactory. Section 2.4.9E1 of the city's land development regulations establishes the standards with which all site plans must be found compliant. The standards are listed there before you. Application has been reviewed for compliance with the standards of section 2.4.9E1 with the findings located in the staff report. Specifically, consistency with the comprehensive plan, as stated, the evaluation of the applicant's consistency with the comprehensive plan has been included with the staff report, and staff has found the application to be compliant with comprehensive plan, consistent. Use allowed in the zoning district, use type of medical office, specifically dentist, is a permitted use in the community commercial zone district. Zone district use specific standards. The use is allowed in the zone district in accordance with Article 4 use regulations. Development and design standards. It has been reviewed for compliance with all the relevant standards of Article 6, including those listed on the screen, and found to be in compliance with each. The subdivision standards do not apply because there is no subdivision being proposed by this application. Complies with other relevant city laws, ordinances, regulations, requirements of state and federal law and regulations. Applicant has been evaluated against section 6.8.2 design standard. I've got a little bit typo there. Something got missed in the translation, but it was found to be compliant with all the city's laws, ordinances, regulations. Section 6.8.2 of the city's land development regulations establishes the standards with which all business uses, unless exempted. This is a repeat. I'm sorry, this somehow got added in there, copied and pasted back and forth. My apologies. A public facilities analysis, impact analysis was done, also found to be acceptable in all categories that were pertinent to the application. With no residential being presented as part of this application, recreation and public schools was not affected. Therefore, staff's recommendation is that the Planning and Zoning Board find the site plan application PSP 25-0012 for Alachua Outparcel LLC to be consistent with the City of Alachua Comprehensive Plan and in accordance with the City of Alachua Land Development Regulations, and approve the site plan subject to the 5 conditions found in Exhibit A and located on page 25 of the April 21st, 2026 staff report.
Any questions? Public comments? Having seen none, could we have a motion, please?
I'll do it. I move that based upon the confident substantial evidence, the presentation before this board and staff's recommendation, the board finds the site plan application for Alachua Outparcel LLC to be consistent with the City of Alachua Comprehensive Plan and in compliance with the City of Alachua Land Development Regulations, and approves the site plan subject to the 5 conditions found in Exhibit A and located on page 25 of the April 21, 2026 staff report.
Second.
It's been moved and properly seconded. Ms. Highlander?
Aye.
Ms. Judd?
Aye.
Mr. Minninger?
Aye.
And chair votes aye. The motion passes. Move on to item F.
Thank you, Mr. Chair. Item F is application PSP 25-0009, also Westside Commons, and this is the Chipotle site plan. It's a request by Alachua Acquisitions LLC, the applicant and agent on behalf of Alachua Out Parcel LLC, the property owner, for a site plan proposing the construction of an approximately 2,366 square foot restaurant with drive-through service with associated site improvements on a 0.88 acre subject parcel property generally located at the northwest corner of US Highway 441, northwest 173rd Street, also known as County Road 235A. Tax parcel 03044-001-002. Future land use is commercial. The zoning is community commercial. And this also is a quasi-judicial hearing. So after the introduction, the presentation, if present, would be by the applicant, then followed by the affected parties, followed by staff report.
Thank you. Anyone that wishes to speak on this matter, please stand.
Do you swear or affirm testimony you're about to give is the truth and nothing but the truth?
I do.
Thank you. Mr. Attorney.
Do we have any ex parte communications on this matter?
No.
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 No. Is there anyone that wishes to request affected party status? Haven't seen none. Anything further from the applicant? Okay. Mr. Thomas.
Thank you, Mr. Chair. Again, this is the Chipotle site plan application. It's approximately 0.88 acres property on the corner of US Highway 441 and Northwest 173rd Street. Proposes 2 ingress and egress points via shared driveways, one connecting to US Highway 441, one to Northwest 173rd / County Road 235A. Stormwater is proposed to be directed to an off-site facility that is part of the Westside Commons infrastructure plan, which is approved on December 8th, 2025. Here is the aerial, very similar to the one you just saw. It has the corner parcel, which is where the Chipotle would be located. Again, there's the general view of the site plan. As you can see, there's parking adjacent to 441 and to 173rd Street. Does have a drive-through right here. Again, neighborhood meeting was held on June 2nd, 2025 at the Legacy Park Multipurpose Center, meeting room number 2. As required by section 2.2.4, city's land development regulations, all property owners within 400 feet were notified via mail, and notice of the meeting was published in a newspaper of general circulation. Materials submitted by the applicant indicated the meeting was attended by 3 members of the public. The application has been reviewed for consistency with the city's comprehensive plan. Specific goals, objectives, policies of the application were consistent with can be found in the following elements: future land use, transportation, community facilities, conservation, and open space. And a full evaluation of the specific goals, objectives, and policies is included in the staff report that you have before you. Again, an environmental conditions analysis was conducted on the site, and all elements of the analysis were found to be satisfactory. It was also evaluated for compliance with the land development regulations based on the criteria listed on the screen, and it was reviewed for compliance with the standards of section 2.4.9E1 with the findings located in the staff report. Specifically, consistency with the comprehensive plan, evaluation of the applicant's consistency with the comprehensive plan has been included within the staff report. Found application to be consistent with the City of Alachua comprehensive plan. Allowed in the zone district, use type of restaurant with a drive-through or drive-in service is permitted is a permitted use in the community commercial zone district. Use-specific standards. The use-specific standards for restaurants with a drive-through or drive-in service are established in 4.3.4A2 of the city's land development regulations. The application has been reviewed against and found to comply with the use-specific standards. Development design standards. Application's been reviewed for compliance with all relevant standards of Article 6, listed on the screen there, and found to be in compliance with those standards. Again, subdivision standards are not applicable to this application as no subdivision is proposed. Complies with all other relevant city laws, ordinances, regulations, requirements of state and federal laws and regulations. Application has been evaluated against that criteria. Again, haven't cut and paste error here, but has been evaluated against the requirement to comply with all the relative city and state and federal laws and found to be compliant. Public facilities impact analysis was done on this parcel as well. All items of the analysis were found to be acceptable. Again, recreation public schools not applicable because there's no residential component. Therefore, staff's recommendation is that the Planning and Zoning Board find the site plan application for Alachua Outparcel LLC to be consistent with the City of Alachua Comprehensive Plan and in compliance with the City of Alachua Land Development Regulations, and approve the site plan subject to the 5 conditions found in Exhibit A, located on page 25 of the April 21st, 2026 staff report. That concludes the presentation.
Thank you. Members, any questions? Any comments from the public?
Hello, Mr. Chair, Soria Lindberg. Who doesn't like burritos? So closest Chipotle is like 30 minutes away. I live right next to it. And I have some real safety concerns I'm going to bring up. I know it's allowed by right, but I just want to share my concerns, especially for those of us who live off 235A down that street. 8 o'clock in the morning, my kids went to a new school. Now we turn left on 441 every morning from 235 to I-75, bumper to bumper traffic. 3 o'clock to 6 o'clock, bumper to bumper. I think when it comes to Alachua, we have different personalities for Good Life Community. In my side of Alachua, traffic is such a big issue because we have road segment D, 75 to 441 in front of Publix is a D. And something I don't think is very genuine, which it's in the packet, it's online that I saw. The applicant submitted a traffic study with this presentation. It is not presented in front of you for the public to see on the thing. And their traffic study said that at peak AM hours, it would be an E. I looked it up. What does E mean? On a scale to A to F, F means gridlock. So we're not Manhattan when the president drives through, but it's gonna get there. And at another point in the traffic study, it said 93% capacity for that intersection. There's no other way for us to leave 235A unless we go down the big bumpy road and take 6 miles around the way. So I encourage you to ask about the traffic study and see how that impact is, because I didn't comment on the dental site plan because a few people going to get their teeth cleaned does not really affect the 8 a.m. to 5 p.m. crowd. A drive-through burrito store will, and I'm going to be one of those cars that go through. There's also, there's a one in, one out, and the applicant was very receptive to our comments in the neighborhood meeting and since then about delineators and other things, but it's just going to take a bad mood in a truck to, if you're coming down 441 from Publix to turn right at the high school, there's nothing that's going to stop you from turning left into that restaurant area. But what happens is everyone else's traffic is backed up to leave 235A. So you're going to have people stopping, waiting to turn. They're going to cut. And you know what else is I've noticed since the Chick-fil-A opened? High school students, they're crossing. There's nothing really safe for them dodging traffic. So they're going to come across to get Chipotle. They're going to the Chick-fil-A. And you're the only board who signs off on this. It's not going to the commission. It's your kind of your responsibility. So I know it's gonna, I don't know what we can do about that, but having drive-through service for a very popular restaurant is going to bring people down from the interstate. It's going to bring people from West Gainesville, Newberry, a lot of stuff. So traffic is going to be an E. And I mean, those are the facts. So if you want to ask about that, so everyone can see that, that'd be appreciated. And I'm concerned about lighting for the high school and my daily commute. I don't want to move out of my house because the traffic is bad, but we're getting really close to there. So thank you.
Thank you. Any other public comment?
Hello, my name's Deborah Havlick. I'm a resident of Alachua. I agree about the traffic. I'd really like you to consider that. Also, I know it seems that anyone who wants to do anything here, our city planner is just cool with it. But I think we need to start slowing down before we add something this extensive and work on our traffic, work on our sewage, and also like adding, I know this was a different, just all this water. And I think we need to really look at our traffic and find ways to make it work before we do something like this. We need to slow down. Just pause this a little bit.
Thank you. Is there anyone else that wishes to speak?
I would like to second the points that the previous ladies made.
Could you tell us your name, please?
Bill Smallbine. I live in Alachua, and we moved up here from Fort Lauderdale in 2023. And one of the reasons we moved up here was to escape the very thing that the previous commenters are fearful of. And we're already seeing in a very short time where the exit 399 to get to Alachua is backed up 2 miles on the interstate, and that can come at just about any time of day because of all the truck traffic. There's a residential community being built across the street from the Publix. Tell me what you think is going to happen to 441 when all their houses are built and the residents have moved in there. One of the places my wife and I previously lived beside South Florida was in Brevard County. And when I worked on a radio station there, one of the things we found just in the course of our news and show prep was that if you wanted to build a Walmart in Palm Bay off of Palm Bay Road, the company had to build the extra exits and extra turn lanes so that they would alleviate the traffic problems there. Has there been any such move made on developing new restaurants and other commercial businesses in this area? Because between that and the traffic, you might be making choices now that are going to come back to bite all of us later. And thank you.
Thank you.
Good evening, Mr. Chair, board members. My name is Tamara Robbins. At what point does this board actually take a serious look at what is the consequence of all these approvals and the increase in traffic? I mean, this is a real situation that you all are creating, being part of creating. But when do you put the brakes on and say, wait a second? I mean, Ms. Surya said, like in this report, it says it's a level F, E, whatever, failing. It's failing. Like if any of you traveled that corridor right through there, it is failing. So when do you, and this is just a sincere question, when do you stop and actually take a look? When staff says, there's like no impact, there's no impact to anything. How can that possibly be? Like collectively, you have to look at everything collectively. Are you looking at each thing like as a little one piece of a puzzle rather than how it all fits together? Because it all fits together. It all is interrelated. In 2001, when the first distribution center was on the table, like there was talks about how the truck traffic is not decreasing. The semi traffic alone is a horrible addition to this community. It impacts every county road. It impacts every state road. And now you're just adding more and more vehicles to it. And so I really would like an answer to this question. And I think the public deserves it. When do you put a slam on the brakes, no pun intended, and actually really look at the collective impact of these approvals and on the impact on the traffic in this community and the quality of life. You know how much time we lose sitting in traffic? Idling, gas is $4 a gallon, and we're sitting there idling away. Oh, isn't that fun? No, it's not. It's our quality of life. This is not the good life community sitting in traffic. It's not. It's not breathing the exhaust fumes. It's not burning up fuels, contributing to the climate impacts. It's not. This is not good. So when do you all start planning? Planning and zoning board, not just a zoning board. We call you the rezoning board. Just saying. It's true. It's been going on since I lived here, 30 years at least. It's the rezoning board. Would you please take your title of planning seriously and actually plan? I mean, I know we have a comprehensive plan, but if the application doesn't fit the comprehensive plan, y'all just change it. The idea of a comprehensive plan is that it is adopted and then you stick to it and you say, nope, not in our plan. But almost every agenda you have, you change the comprehensive plan. There's an application tonight to change the comprehensive plan. What is the point of having a comprehensive plan if you're just going to haphazardly change it? That is not a plan. So I really would like to ask, I know y'all are looking pretty uncomfortable right now because I know I got 5 minutes and you're just kind of like, is there time up yet? I know what you're thinking. You're looking at the clock and, everywhere else. Please explain to this public, when are you going to take a look at the traffic impacts and what you're really doing to this community and the quality of life of everybody that lives here and even wants to visit here? Would you please do that? Thank you.
Thank you for your comments.
Good evening. My name is Gary Pappas. I live at 16104 Northwest 188th Street. I didn't intend to speak until items H and I tonight, which are coming up, but I am so glad these folks have come up and talked to you about traffic and congestion issues relating to what you're doing to 441. You're going to hear from me again a little later tonight, but I just want to reiterate what this fine resident just said who left, and this fine lady who are talking about traffic and congestion in the so-called good life community. You look at each item in a vacuum, and you are not looking at the total effect of what you are doing to this community. I-75 is backed up at the 441 exit every single day. 441 backs up all the way to 188th Street every single morning and every single evening. And you just keep approving and approving and approving commercial development. And you're turning 441 into Archer Road and Newberry Road. And that's not why people moved here. I moved from South Florida to get away from congestion and traffic, to get away from big box stores. And that's what you folks are doing by approving every single commercial development down 441. I'll rest my case now. You'll hear from me again later on the next, on the H&I agenda items. But please answer the question that fine lady asked.
Thank you. Any other comments? Please come forward.
Good evening, Mr. Chair and members of the Planning and Zoning Board. John Havlick, a resident here of Alachua. Going to kind of maybe just reiterate some of the concerns just expressed. You've probably heard me say this before, but in my work over the last number of years, I've had a lot of opportunity to travel around Florida, around the country, and I could always tell when I would come back from South Florida, I was getting close to home after I came across Paynes Prairie, Gainesville, and everything kind of got slower and quieter. And growth is going to change that, so I understand that. I came from a very rural area of Pennsylvania before moving here 16 years ago. And in that time, I can honestly say, wow, the traffic's really increased. So Most mornings I get up early and I experience the morning congestion on 241, 235 right downtown, trucks, traffic, everyone going to school. It changes at summertime. But I also typically go for a swim most mornings, and I go out 441 out to one of the springs and I do a morning. And I've just noticed, like when you come down the ridge, past the new Wawa and that, those cars are lined up all the way down the straightaway until it curves to High Springs. And that's just 2 lanes. And it reminds me of Ocala on the east-west routes. They're just jammed all the way back and forth. So I had a conversation with another resident here. He's not a permanent resident. I think he has a out-of-state domicile. But nonetheless, he does live here, has property. And we were talking, and he had brought this up about the roads and the traffic. And I think one of the concerns we should have is that we can approve the site. There's an empty piece of land. Someone wants to develop it. Makes sense. Good location. Get all that check. But I do think there's kind of like a mission creep where it's like we don't realize each little motion and approval is leading us down this path of where we have a hard time readjusting. We paint ourselves into the corner, literally. And I'm just concerned that we don't have a real plan for how do we deal with that congestion along 441, even like where Miapa and Popeyes are. You have to kind of get off. It's not like they're just right where you can just come right in and out of those and it interferes with an entire intersection. You have to kind of go around the back way, or you can only come in one way to that particular location. So I think it's just going to become problematic. And with the school and all that traffic, like, whew. So, I mean, I know it can't be resolved in this one meeting, but I would agree, and I think we should all take to heart that, like, at what point have we gone too far and we've maybe made decisions we can't back out of? So that would be something to think about, and maybe we need to challenge ourselves a little bit more about how do we deal with some of this. Spoke again with this resident, Mr. Tuttle. He's approached the city on a couple. He's speaking with the city manager about some alternatives, possibilities for the truck routing, and I just think there's a bigger plan that we have to look at. So I know it doesn't fall within the purview of this zoning board. Perhaps though, it's something we should maybe take a look at, bring up with staff, particularly the city manager. What are we really going to be able to do to coordinate with the county, 235A and those routes, and then with the state with 441? Seems like there's just some stuff that needs to get resolved. So if you could be considerate about that, I would be mighty grateful to y'all. Thank you.
Thank you.
Hi, Mr. Chair. Sheila Spence. I own a building here in the historic area and live in Newberry. Yes, this is my first planning meeting, and I've heard 3 things, actually quite a few things that gave me pause. The saturation of car washes is surprising to me in that area. It does make me wonder about the impact on water, especially that it's going to be city water. How would that affect homeowners and their water? That much use in that area? And then is there anything in the plan should these car washes or high water use companies, can they build wells? I mean, how does that affect the aquifer? I mean, does anybody address that? I'm sure they'd have to apply for it, but is there a plan for that type of activity? And then another person brought up the congestion right there at one. We heard 3 different brand new businesses on 173rd and 441 right there in this meeting. Turn lanes, having to pay for something in the medians, something, because I live south of here, but I do happen to go to High Springs once in a while, and even I know how congested it is. And I hate to see us turn into a Newberry Road or an Archer Road where everything is built straight up onto the edge of the highway, and there's nowhere to expand except with eminent domain or something, because you're letting these businesses get right up to the edge of 441. So even if you did want to address traffic in the future, we don't have any room for turn lanes. So maybe you should factor that in and start pushing things off. Like when you first let the Lowe's come in, that's way off the highway. I thought that was brilliant. It has a lot of space. There's a lot of ways to ingress and egress. The trucks can get in and out. And that's another thing. We've got all these delivery trucks for all these businesses that bring things in. Chipotle's, they don't shop at Publix. You know, they have spaces, and then they have, you know, they're going to have a lot of commercial activity as well. And then the last thing I wanted to talk about was, it was brought up, and I thought it was a good point about the fire station, that it's not on a visible highway. And I thought it was a good discussion,
Well,
but
let's keep the discussion to this item, please.
okay, well, I'll leave it at that. But I just thought I think more discussion could happen, and I appreciate everybody here, and I don't want to be a burr, but I think it's really important to think about the traffic factor, because you've got a lot going on. So thank you very much for letting me speak.
Thank you.
My name is Umesh Sharma, and I was excited to hear the Chipotle plan, but the point she raised about the traffic is really, really very important, because I had traveled and lived in very big cities, Chicago, New York, LA, everywhere, Houston. The traffic really, and I am also experiencing, I moved here a year and a half back, right in front of the city hall, like 441 and 140, especially the trucks. I don't know. And the trucks, they run very fast. And anytime like you try to come in 235 or 241 or anything, I literally fear for my life. Means I had to kind of see like all lane empty before I turn right or left. And they run very fast. And I one time literally I had a very bad situation. I immediately went to the side. So traffic really, and especially the Chipotle, because I love Chipotle, and many times at the peak hours or evenings, they have a very high traffic. Means even inside the restaurant itself is a high traffic. So of course the cars all outside also. Means it's kind of a. I think there should be. I love the ideas, but accordingly as other speakers has raised the point, especially the trucks. Means I don't know. Means it's kind of a dangerous. Not only the traffic bottleneck, but the way they run totally like out of control within the city. I don't know. Means within the peak hours, I think either they should have some limited time or something, especially within the city limits. I don't know from where they will go, but they need to be kind of, and including the safety bottleneck is okay as well. But so that's my point. Thank you.
Thank you. Any other public comment? All right. Board members?
Mr. Chair, I move that based on competent and substantial evidence, the presentation before this board and staff's recommendation, this board finds the site plan application for Alachua Out Parcel LLC to be consistent with the City of Alachua Comprehensive Plan and in compliance with the City of Alachua Land Development Regulations, and approve the site plan subject to the 5 conditions found in Exhibit A and located on page 25 of the April 21st, 2026 staff report.
Mr. Chair, I'll second for purposes of discussion to get a motion on the floor only at this point. Thank you.
Thank you. Do you have anything else you wish to discuss?
Mr. Chair, I do. I'd like to, I know it's not appropriate for us to respond to citizen comments. I would only say that to say this under board comments this evening. I had had a brief discussion with our planning director about wanting to bring discussion on a topic that I think is very germane to this community, and I think can also roll over to, excuse me, is it next week that we've got the combined commission plan board meeting, Mr. Thomas? Yeah. So I can go into more deliberation at that time. I do think there needs to, and I'll just throw this out. I don't know, or I guess we have to. I don't know Robert's rules. Do we have to vote this motion up or down at this point, and let it see where it's live? But I would like to make a subsequent motion. That's why I said I'll second this for purposes of discussion. So if you want to do a roll call vote on it at that point in time. Excuse me, Mr. Chair, I'm happy to put another motion on the floor.
All right, it's been moved and seconded. Ms. Highlander.
I guess I'm a little confused, Mr. Chair. So
So, Mr. Chair, the motion on the floor is to approve the site plan as presented with the, what was it, 5 conditions in the staff report. That's the motion on the floor right now.
Aye.
Ms. Judd,
No.
Mr. Minider.
Aye.
The chair votes aye. The motion passes.
So, Mr. Chair, my subsequent motion is, and this bleeds into, I guess, all of the ones under the heading of West Side Commons. I don't have all the site plans in front of me. I'm trying to remember how they were, articulated, but if they were all sharing one curb cut off 441, I know from previous experience that there's usually a spacing that FDOT requires on curb cuts on 441. I don't know if Mr. Thomas can respond to that, but I do think as these move, which are not conditions in those site plans now, there needs to be some sort of coordination. At this point, quite frankly, I think it's going to be a little quirky, for lack of a better term, because the trains left the station. But I'm thinking of where you had the MIAPA and all that stuff. You know what I'm saying? The traffic flow was weird, right, as a driver, but it seemed to meander and get people in a more coordinated way. So my question is, could this be done with West Side Commons? I make that suggestion only because I think they've got shared off-site stormwater, right? So that's my question. Thank you.
So, Mr. Chair, they actually have a shared use driveway that encircles the entirety of the property, and they have a shared ingress and egress on 441, a single ingress and egress on 441, and then a single ingress and egress on 173rd that they share.
So, Mr. Chair, following up on that, the ingress, egress off of 173rd Street, 235A, what is the spacing on that in relation to when you start to enter those side roads to get into the high school? How close is that? Theoretically, does that make sense?
If I understand the question, Mr. Chair, trying to determine the distance from the ingress egress point to the intersection for the, I don't have that information on me. That was contemplated during the infrastructure plan approval process that was approved by the city commission in December.
Okay, so in other words, all that has been done, for lack of a better term?
That is correct.
Okay. I guess my final question is there not, I'm trying to think when you get traffic flow, and again, not a traffic engineer, traffic flow, I don't know, would it be something that, I'm just thinking when you are trying to make that either cross through the intersection through 441 or coming, I guess, north at that point towards High Springs, making a right, isn't there a turn lane right in front of the high school, right? That a dedicated right lane there, right?
There's a right turn deceleration lane. Yes.
Right. Okay. So there wouldn't, okay, I think I've answered all my questions. All right. Thank you, sir.
Thank you. So do you have another motion you wish to put forward?
Not at this time. My questions have been answered, but it does sound like a lot of this has been done already. Do you know what I'm saying? And I think, not ignoring the comments we've heard tonight, I can't speak for the other members, and this is not the appropriate time, but under board member comments, I think you'll find some response. Thank you.
Thank you. Let's proceed with item G, please.
Okay. Thank you, Mr. Chair. Item G is also Westside Commons, the third and final Westside Commons application, PSP 25-0015. It is an application for a Dutch Brothers site plan, request by Alachua Acquisitions LLC, the applicant and agent on behalf of Santa Fe Hills Church of Christ, the property owner, for site plan proposing the construction of a 1,035 square foot restaurant with drive-through service with associated improvements on a 0.9 acre subject property located again at the intersection, generally located at the intersection of US 441 and Northwest 173rd Street. On tax parcel 03044-002-000. The future land use is commercial and the zoning is community commercial. As this is a quasi-judicial hearing, the applicant would be allowed a presentation first, followed by any affected parties, and then followed by the staff report.
Okay, thank you. Anyone that wishes to speak on this item, please stand.
Do you swear or affirm the testimony you're about to give is the truth and nothing but the truth?
I do.
Does the applicant wish to speak again?
Yes, thank you, Mr. Chair. Chris Blurton with Interplan LLC, 220 Central Parkway, Altamont Springs, Florida. I did want to address some comments that were brought up by members of the public during the last public hearing. And obviously, I'm sure we'll hear some of the same comments on this hearing as well. Very quickly, going over some of the issues. I know Ms. Lindberg, correct? Thank you. Brought up some issues with the traffic study that was submitted. The traffic study that was submitted originally, that was before we had the individual users really nailed down for this particular development. At that time, we basically assumed the highest, most intensive use for the parcels here at 441 and 235A. So we assumed that there would be 3 fast food restaurants being built at that time. And those are the assumptions that the traffic engineer used in his traffic generation numbers and the level of service that Ms. Lindberg noticed that it would be a level of service E. I don't know what the level of service would be with the current development plan, but it would not be a failing level of service. And what we're actually looking at with the proposed plans is quite a bit lower than what was originally proposed or originally envisioned in that traffic study. And also that level of service does include other reservations for other developments that have not been built and may never be built. So that's all the site plans that have been approved and residential developments that have been approved, but aren't necessarily under construction at this point, and may never be under construction. Based on the community meeting, and just to address real quick, I know Mr. Thomas did mention that the 2 driveways, one being constructed on 441 and the other being constructed on 235A, those will both be right in, right out only driveways. And based on, I think Ms. Lindberg said again, we did hear the community feedback at the community meetings and spoke to the community members. Their concern, of course, was left turns in and left turns out of that 235A driveway. A raised traffic separator was put there to keep traffic from turning left into or out of the development. I realize somebody with a big truck and sufficient lawlessness can potentially drive over one of those traffic separators, but it is an illegal motion, and it definitely would make it uncomfortable for drivers. We did add signage there as well to enforce that left turn prohibition. There is a turn lane being constructed on US 441 into the development. Both of those driveways have also been pushed as far as possible away from the intersection while still keeping a representative buffer from especially the residential in the rear. That was another thing I did want to mention about the Chipotle. The Chipotle, while it does have a drive-through, it does not have a menu board. And if you look at that site plan again, I realize it was approved, but I did want to point out that it does not have a menu board and it does not have any parking at the rear of that development, just to keep all the development and all the traffic more or less as far away from that residential home, the existing residential home, as possible. I think that's all that I have at this point, but I'm here to answer any further questions that the board may have. Thank you.
Could you please clarify for me the traffic divider on County Road 235? Is that the concrete, the short, I don't know, 12-inch maybe, 10-inch?
I think they're roughly 6 inches.
6 inches?
Correct. Yes. Essentially, I've heard it referred to as a pork chop, or essentially has 2 radii that follow the driveway out and in.
Now, I'm talking about actually on 235 to prohibit the left turn. Is there any divider going on that? So
No,
it would
there
be
is
in
not.
the yellow line area?
Correct. That will remain just a double yellow line.
Okay. Did answer your questions about the turns going in?
Yes, Mr. Chair, thank you. But, it's unless you can do something like they did with the, what was it, the Chick-fil-A thing, it'll be in essence, it'll be a double yellow, right? Which means that if you make a turn, but there won't be any physical obstruction there is what I'm hearing, correct?
Not in the pavement of 235A, which is a
Right.
county road. No, it'll
Right.
be in the driveway, very visible in the driveway, but it will be in our driveway off of the 235A pavement.
Okay, all right.
Okay, thank you.
Thank you.
At this time, does anyone wish to be an affected party? Okay, having seen none, Mr. Thomas.
Thank you, Mr. Chair. Again, this is a site plan application for Dutch Brothers Coffee with the associated drive-through on 0.9 acres, again, at the US Highway 441 intersection with Northwest 173rd Street. Proposes 2 ingress-egress points via shared driveways, one connecting to US Highway 441, one connecting to Northwest 173rd Street. Stormwater is proposed to be directed to an on-site facility. It's not on site of the Dutch Brothers, but it's on site for the infrastructure plan for West Side Commons. So technically it's off site. Stormwater facility as part of the West Side Commons infrastructure plan approved on December 8th, 2025. Again, here's the aerial depicting that this is the third in the line of developments on this one site. And here's your general overview of the site plan. On this one, you can see the right in, right out onto US 441, and here's the deceleration right turn lane going into that driveway. And then again up here, and you can see right there is the directional impediment that is going to be put in place. Again, right in, right out only. Neighborhood meeting was held on June 2nd, 2025 at the Legacy Park Multi-Purpose Center Meeting Room number 2. As required by Section 2.4 of the city's land development regulations, all property owners within 400 feet were notified via mailing, and notice was published in a newspaper of general circulation. And materials submitted by the applicant indicate that the meeting was attended by 3 members of the public. Application was reviewed by staff for consistency with the city's comprehensive plan, evaluated against the 4 specific goals listed, elements listed there: future land use, transportation, community facilities, conservation, and open space. The full evaluation is in the staff report. An environmental analysis report was done, and all of the elements of the analysis were found to be satisfactory. Section 2.4.9E1, City's Land Development Regulations, establishes standards with which all site plans must be found compliant, which are listed there. Application has been reviewed for compliance with the standards of Section 2.4.9E1 with the findings located in the staff report. It was found to be compliant. Specifically, as we just already stated, consistency with the comprehensive plan, evaluation of the applicant's consistency with the comp plan has been included in the staff report, and it was found to be consistent with the city's comprehensive plan. Use allowed in the zone district. The use type of restaurant with a drive-through or drive-in service is permitted. This is not going to be a restaurant, but it falls into the same category as restaurant with a drive-through. It is a permitted use in community commercial zoning district. Use-specific standards. The use-specific standards for restaurants with a drive-through or drive-in service are established in Section 4.3.4A2 of the city's land development regulations, and has been reviewed against those and found to be compliant with those specific standards. Development design standards. Application has been reviewed for compliance with all relevant standards of Article 6, as listed here. And in subdivision standards, again, there's no subdivision occurring with this application, and therefore is not applicable to this application. Complies with all the other relevant laws, ordinances, regulations, requirements, state and federal laws. Staff analysis indicates that they are compliant with all of those. A public facilities impact analysis was completed on this application as well, found to be acceptable in all the categories listed. One point of I'll make note, it does not indicate that there is no impact on these. It indicates this analysis indicates that the impacts are acceptable under our comprehensive plan. And so there's a fine distinction there. It doesn't say that there's no impact. It just says that the impacts have been evaluated and that they comply with the city's comprehensive plan standards for level of service. Therefore, staff's recommendation that is that the Planning and Zoning Board find the site plan for application PSP 25-0015 for Alachua Out Parcel LLC to be consistent with the City of Alachua Comprehensive Plan and in compliance with the City of Alachua Land Development Regulations, and approve the site plan subject to the 5 conditions found in Exhibit A and located on page 25 of the April 25th, 2026 staff report. Happy to answer any questions if the board has any.
Thank you. Are there any questions from the board?
Mr. Chair, I just had a couple of quick questions. I was looking at, excuse me, at the site plan. And this is more just, I guess, informational question, but there was previously no sewer on that side of the road, correct? And they're bringing it over from, we talked about this, I think, at the last meeting, they're bringing it over from.
Yes, Mr. Chair, sewer is being made available before they can final the certificate
Is
of
it
occupancy.
connecting to Horizon Park, to the office park there, or is it ending before there?
Mr. Chair, I couldn't tell you the direct line that they're connecting into. Unfortunately, I don't have the answer to that with me.
Okay. The other question I had, and forgive me, there was a lot that we read through, but was this, wasn't there something in there as well about delivery traffic to these 3 businesses?
Mr. Chair, that's in the conditions that they'll be within business hours. So you wouldn't have the delivery trucks, in the early or the middle of the night or in the early hours of the morning, waking people up with the backup signal, sirens or beepers and things like that.
Okay, thank you.
Any other questions? I believe we need to poll the members.
Any ex parte communications on this matter?
No.
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 No. All right. Any public comment on this?
Hello, Mr. Chair. Soria Lindberg. I'd like to thank staff for the condition to not have deliveries during business hours. If there is a beep in the Chipotle parking lot, I will hear it from my house. And hopefully we don't hear any drive-through order. Oh, no, there's not going to be a drive-through order, but anything else. So when I noticed things go through the development process, when they were here for the rezone or land use change, they say, don't talk about traffic. It's going to be addressed when we do the site plan. Again, they're not showing the traffic study. We learn more from the applicant. And when they say that traffic is acceptable, I've heard staff say in many meetings that a score of D is acceptable. And it's D right now with that place being grass. So I know it's zoned a certain way, but I'm wondering if we can mitigate it. If that's in the parameters of the board, for example, the dental office, it's not going to have that many trips. Coffee will have more trips than a $14 burrito. I know that because I'd rather buy a $5 coffee some days than a $40 order for my family. So I know you're going to take this decision very seriously because there's thousands of people who are going to be affected by this in that intersection. And we also heard that traffic backs up on I-75. My mother-in-law watched my child last night, and she said she was in traffic on 75 for exit 399 for 1.5 miles. And that was at about 5 o'clock. So imagine people on the interstate saying, everyone hold it, we're going to go to Chipotle or we're going to pick something up. So it's just going to bring more regional traffic as well as the local stuff. And everyone who lives in this area, we signed up for things how it is now, but now everything is just getting accelerated when it comes to the traffic. There's going to be a little bit, but now every morning when I pull out of 235A left to go to 75, only 3 or 4 of us can take a turn without our tail sticking out. And I'm not going to block 441 traffic. So it's very important, especially with such an intense use of coffee. Ask, can they come back and give a less intense use, more medical offices, something more, it's community commercial that's oriented that way. Thank you, Member Judd, for acknowledging the traffic. Because again, for this item, we didn't see it come up. So members of the public who didn't download a 90-page document couldn't see that traffic study. I think it should be up there. It should be transparent. You might have noticed someone made a petition for the traffic on there, so we're just going to keep hearing more about it as well. There's still more homes being built on that road. Briarwood has dozens of more. They're building that behind me. So it's interesting to hear what was considered for the traffic study that said it would go from a D to an E. And I also noted in the item before there was going to be 93% capacity. And also based on the other items on this agenda, it's just getting higher and higher. So someone mentioned the double yellow line on 235 in front of the high school. Again, if you're hungry and you have a bad idea, you really need coffee, what are you going to do? You're going to turn right, like you're going to the high school, and you're going to do a U-turn. You're going to do a U-turn into oncoming traffic. But you can't really put, this is my just personal opinion, too much on the road because there's houses right there too. So if you were to put so many lanes down, then I don't know how those people would go to the houses, or they're going to come in front of my neighborhood and do a U-turn at the bus stop or the bus parking lot. So I just really don't want to get in a car accident sitting in my lane and someone else just comes through down that deceleration line, because if you're going down 441 to High Springs from Publix, you got your 2 lanes of traffic and you have the lane to go to the high school. The one that goes to the high school is always empty because that's what it's there for. I can imagine, because I take that lane every day and I'm like, oh man, glad I'm not in that lane. You can speed down that lane, turn right like you're going to high school, do a big U-turn. I know we can't really make a rule about that beside it being a bad idea or if anyone watches it. But it is a safety concern. So again, if anyone, I've heard people say, oh, Dutch Bros, there's a line going out to the road in Gainesville. It's very popular. It's a very intense use. So I'm just concerned about it's very intense use at such a vulnerable intersection. Like if this was next to Turkey Creek, smooth sailing. So if you live on this road, you know how hard it gets. So thank you for listening and considering.
Thank you. Any other public comment?
Thank you, Mr. Chair, board members. My name is Tamara Robbins. So obviously a lot has been spoken about the automobile and truck traffic and the impact. And so I'm here to ask that in that area, that's a school zone. So there's school buses, there's drivers that are student drivers because, they're of age. Most of the high school kids, well, at least when they get to be a junior and senior. So they're new drivers, right? Driving to school or having their parents pick them up too. They park in the Publix parking lot lots of times to pick their kids up. So it's a school zone. So imagine that there's going to be, and there already is, a lot of foot traffic going from the school diagonally, getting over to Chick-fil-A. Now there's going to be a Chipotle. So they're going to be crossing roadways on foot. So first I was talking about the vehicles, right? That's an issue. But the pedestrian traffic that is trying to maneuver and manipulate and that intersection, which is pretty crazy, right? So there's like going to be people doing U-turns, right in, right out. If somebody took a right into to this location and could only make a right out, the only way they could get back to 235A, like to get back to schools, they're going to have to take a right, go on 441, make a U-turn, come back, get in the left-hand turn in 441 with all the trucks and everything else and make a left-hand turn to get back onto 235 to go back to school if they're in their car. But is there any coordination between the city, like the planning board and the city and DOT on how are you going to install some sort of crosswalks with some timers on it that are going to protect the pedestrians? So now what they're doing, I haven't personally witnessed, it's hearsay, but somebody I was sitting next to said she has witnessed it. And so the students are out just cruising through, jig-jagging through the traffic. They're just trying to get where they're going to go while they have like 10 minutes between class, right? Grab a coffee or whatever they're going to do. So it's just like the combination is just so crazy to me that I can't believe there isn't more thought. So I'm going to read to you guys that we have a comprehensive plan. Definitive of comprehensive means covering all or a broad range of elements, details, or information, rendering something complete, inclusive, and thorough. Comprehensive plan, right? So when I see a map put up here with one site plan, and it's like one tiny little portion of the city of Alachua, everything else that's been approved should also be on that map. Comprehensive map. Okay, that last map that was put up there for Dutch Brothers doesn't even have the site plan for Chipotle or the dental office on it. So if you get a big aerial view, I mean, come on, these people have computer programs, right? I mean, board member Menadir, you're an engineer. You know you can overlay stuff all day long on diagrams, right? So why are you not getting maps that are showing the overlay of what is going on? Right? The visual that you guys are showed is like an empty 441. Really? Never is that like that. Right? They're like fabricated. They're almost like AI generated visuals that you're being presented like this is what's reality, and it's not. It's not comprehensive, it's not reality, and it's not showing you all of the information that you should have in order to be making decisions. And it's all possible, right? With all the technology and everything. I mean, you have drone images, you have all kinds of stuff, aerial views, and that the maps could be comprehensive so you could really see how the site plans were interacting with each other. And when the applicant or the staff says, oh, this doesn't have a residential aspect, what about Briarwood? There's like hundreds of homes right down there on 235A. That is a residential neighborhood that doesn't happen to be part of this one application, but it's part of the whole comprehensive view of what is going on. So read the definition of comprehensive again and look at how the plan that we have is as far away from comprehensive as you could possibly be. And technology allows for much better application and consideration. Thank you.
Thank you. Any other comments from the public? Having seen none, is there any?
Again, my name is Deborah Havlick, a resident of Alachua. I think it's getting dangerous. It's seriously. I hope that you really consider what she said. Our only recourse now for anyone else planning to put in any, there's a lot of people who already have the coffee places that are already here. I mean, maybe you can consider buying them out or something. I don't know. But as a resident, I will tell my friends, you're going to keep putting new places in here, you better going to have to rely on outside people because there is something called a boycott. I'm just saying. You keep adding things. That's our only recourse, is to say we're not going to go to these places. So you might want to consider that if you're planning on. I think our city planner should consider this comprehensive plan and not approve everything that comes our way. We already have a lot of places you can buy coffee here. We already have 2 car washes. And I think we need to pause. And also, we didn't even know that the traffic was going to be E. And our city planner should have told us that. We found out from a resident.
Thank you. Any further questions from the board?
Mr. Chair, I have a procedural question. I know my other question, and then it kind of got answered. And I said, oh, okay, sounds like that's already been decided, aside from, what the planning department, may have recommended. Is there, Mr. Thomas, if I may, is there a way to, I don't know how far it's gotten, is there a way to revisit the infrastructure site plan that's referred to from last December? And I'm assuming the master stormwater was part of that dialogue, was it not, or no?
Mr. Chair, all of that was a part of the infrastructure plan that was approved, so it was master stormwater plan. master plan like, it's an infrastructure plan, but it's a similar concept in that the stormwater for this development will all go to a centralized location. They have the shared driveway with the shared ingress and egress. And so, as far as whether or not it could be revisited, generally only at the request of the applicant, but I defer to the city attorneys for any further comment on that.
Mr. Chair, and again, thank you, Mr. Thomas. The reason why I'm asking that is perhaps, given, well, we've heard comments tonight. Again, I'm not an engineer. I am familiar with that area. And there are a lot of other areas in Alachua that have concerns and issues such as this, and I'll talk about them later in the meeting. This is just tip of the iceberg, if you ask me. But in any event, is there no way that we could, if the applicant's willing, ask them to rethink a plan on that traffic flow that perhaps doesn't, I'm saying, I don't know, maybe not come off of 173rd Street. I don't know, you know what I'm saying? But is there a way that that could be done, or would that be a condition that's too late now, or what?
Mr. Chair, the construction plan approval results in a development order, which is now, what was the date of the
December
adoption?
8th.
Okay. So you have 30 days, parties have 30 days to reconsider on the board, possibly less by your code. Anybody who wants to appeal that had 30 days. So currently, it's a non-appealable final order. And if you were to rescind or revisit that, you would put the city in peril of an action by the applicant who's now relied on that approval.
So thank you. That again answers my question. It's too late at this point. You know what I'm saying? My hope is that the applicant is here tonight and they're hearing that, and that maybe they'll, I don't know, talk to the school board, be involved in that meeting at the next week. You know what I'm saying? To see if there's a better way that we can, before all this stuff is done, you know what I'm saying, a better way to perhaps this, you know what I'm saying? I'm sure there's a lot of folks with bright ideas and bright minds. So anyway, but thank you very much. I appreciate it.
Thank you. Anything else? All right, could we have a motion, please?
Mr. Chair, I'll move that based on upon the competent substantial evidence, the presentation before this board and staff's recommendation, this board finds the site plan application for Alachua Out Parcel LLC to be consistent with the City of Alachua Comprehensive Plan and in compliance with the City of Alachua Land Development Regulations, and approves the site plan subject to the 5 conditions found in Exhibit A and located on page 25 of the April 21st, 2026 staff report.
Second.
It's been moved and seconded. Ms. Highlander,
Aye.
Ms. Judd,
Aye.
Mr. Minider.
Aye.
Chair votes aye. The motion passes. And then before we move on to item H, we're going to take a brief 10-minute recess. All right, looks like we're ready to get started again. We'll proceed with item H.
Alrighty. Good evening, Chair, board members, Planning Director, and City Attorney. Carson J. Crockett, Principal Planner for the City of Alachua. My resume is on file in the Office of the Deputy City Clerk. This hearing is a legislative hearing, application number PSSC 26-0002, known as the Farmlands Commercial Small Scale Comprehensive Plan Amendment. The item is a request by EDA Consultants Incorporated on NV5 and NV5 Incorporated together as the applicant on behalf of JTFA LLC to amend the future land use map designation from low-density residential, moderate-density residential, and community commercial to moderate-density residential, community commercial, and commercial on an approximately 46.68 acre subject property, which is generally located at 16650 Northwest US Highway 441. The applicant has submitted a companion rezoning application, which is the next item on the agenda tonight. Here we have a vicinity map of the subject property in the black and white hatched border. You can see that 441 runs along here on the north portion of that border. The city limits is the red line to the west here, which also runs along Northwest 188th Street. For reference, we have the Briarwood subdivision and development over here. We have the Wawa on the corner here with Northwest 173rd Street. And then we have Santa Fe Ford a little bit further down 441. There are three existing future land use categories on the subject property, the first being low-density residential, which acts as a transitionary land use category between the more rural and agricultural uses of the city, and then the more urban uses of the city. The low-density residential land use category permits up to one dwelling unit per acre, and the typical use would be single-family residential. The next category on the property is moderate density residential, which permits up to 4 dwelling units an acre, and the typical uses there, mostly single-family residential, but some allowances for townhomes and duplexes. The last one is community commercial, which provides land for neighborhood and community-scale goods and services while allowing for the development of an affordable housing stock. This is a mixed-use land use category, so it permits up to 15 dwelling units an acre in mixed-use developments and permits up to 0.6 floor area ratio for parcels 5 acres or greater in mixed-use developments. The typical uses are generally commercial in nature, including retail, eating establishments, visitor accommodations, etc., with some of those limited residential uses. This is a map of the existing future land use designations. 441 is the white bar running through here. That's the 441 right-of-way. And then the subject property is again in that black and white hatch border. City limits are here in the red, hence why this is all white outside of that. The pale yellow is the low-density residential that currently exists. The brighter yellow is the moderate density residential, and then the more pink salmon-looking color is the community commercial. You may notice that it is adjacent to commercial here and commercial kind of over there. The amendment would remove the low-density residential category, but retain some of that off-site around it. And then the portions of moderate density residential and community commercial would be rearranged slightly and add commercial land use. So the only one we haven't covered yet is commercial. And the commercial land use category provides for general commercial uses as well as more intense and highway commercial uses. It is also a mixed-use it is also a mixed-use feature land use category and permits up to 15 dwelling units an acre, and also permits up to 0.6 floor area ratio for parcels 5 acres or greater in mixed-use developments. Typical uses are also primarily commercial, similar to community commercial. However, that includes regional and auto-oriented commercial uses. So this is what the proposed future land use map would look like. You can see it would continue the commercial future land use from the east-west, while providing for a gradient of intensity from 441 down to the low-density residential, ensuring low-density residential remains as the transition to the ag future land use and the other more rural areas of that part of town, with the community commercial and moderate density acting as an additional transitionary area between the more intense commercial to the residential. The net change of buildable potential out of the future land use change, or amendment, I should say, would be approximately 427 additional dwelling units and approximately 870,000 new square feet of non-residential. Note that that's the future land use component. The companion rezoning component severely limits that. The neighborhood meetings are not required for small-scale comprehensive plan amendments. However, 2 neighborhood meetings were held for the companion rezoning application on September 24th, 2025 and October 22nd, 2025. In total, 12 members of the public attended a neighborhood meeting, either one of them, 12 in total. A neighborhood meeting summary is available in the application materials for your review. Chapter 163.3177 of Florida statutes requires the future land use element of a comprehensive plan provide for a balance of uses, and that allows for the operation of real estate markets to provide adequate choices for permanent and seasonal residents. The comprehensive plan must provide enough lands to accommodate the population projections for at least a 10-year planning period, but may not be solely limited by those projections. The applicant has submitted an analysis, and staff concurred, and demonstrated that despite a reduction in residential land use categories, the proposed amendment would not adversely impact the amount of land needed for a minimum 10-year planning period. The applicant also contends that, quote, developed nature and urban character of the US 441 corridor within the city of Alachua indicates this area is continuing its urbanizing form, and there's a need for additional commercial and residential options in the city and for residents in the context area in proximate cities of High Springs and Newberry, end quote. Chapter 163.3177 Florida statutes also requires that any amendment to the future land use map discourages the proliferation of urban sprawl. Chapter 163.31776A9, more specifically, identifies 13 primary urban sprawl indicators and 8 urban form criteria, which staff has evaluated the application against all 13 primary indicators and the 8 urban form criteria. An amendment to the future land use map is presumed by Florida statute to not be considered urban sprawl if it meets at least 4 of the 8 urban form criteria. Staff notes that the application meets 6 of the 8 and therefore does not constitute urban sprawl. The application has been reviewed for consistency with the city's comprehensive plan. Specific goals, objectives, and policies that support the application can be found in the future land use, transportation, housing, community facilities, and conservation open space elements. A full evaluation of those specific goals, objectives, and policies is available in the staff report. Staff conducted an environmental conditions analysis with the findings included in the staff report. Staff has no concerns related to the items listed here on the screen and notes that the subject property is generally suitable for both residential and commercial development. I would note that the subject property is located in an area of high aquifer recharge potential, and as such, additional geotechnical review will be required at time of final design and engineering. However, preliminary analysis was conducted and independently reviewed, and the city's expert concluded that the property is generally suitable. A full evaluation is available in the staff report, and that letter from our independent expert is included as an exhibit to the staff report. As such, staff recommends that the Planning and Zoning Board find the small-scale comprehensive plan amendment for JTFA LLC to be consistent with the City of Alachua comprehensive plan and transmit such finding to the City Commission with a recommendation to approve. This concludes staff's presentation. I'm now available to answer any questions the board may have. The applicant and agent is also present on behalf of the property owner, and they also have a presentation tonight.
Do you have any questions before the next presentation?
Do we have any ex parte communications, just real quickly while we're waiting for applicant?
No.
None.
No.
No.
Thank you, Mr.
Well, good evening, Mr. Chair, members of the Planning and Zoning Board, Mr. Attorney, Madam Attorney, and Mr. Planning Director. My name is Jerry Diedenbach. I am Executive Vice President of NV5 Consultants, and I am an AICP certified planner, and I have been a professional planner since August 20th of 1990. I say that sometimes because there are people in the room that are not that old. And with me is my esteemed colleague.
Good evening, Mr. Chair and Commissioners. I'm Clay Swager with EDA Consultants. I'm also a certified land planner for 25 years now somehow. A little unusual that Jerry and I are both here. Both of our firms have a mutual client, and this property has some permitting history in the past, and we're looking to build upon that. So we have a joint presentation for you tonight.
Yeah, thank you. And since you don't have a clerk and this isn't the commission meeting, if I could approach and hand the chair to the attorney. These are the complete resumes of the folks that are here participating in this tonight. I wanted to put that into the record and just add a little bit of background. We've heard a lot of good questions tonight. When we saw that we were last on the agenda, I was like, oh boy, we're last. That means late supper or Peloton ride near midnight tonight. But it gives us a great opportunity to listen to the concerns that come forward in the community that are expressed this evening. And as if you put my 36 and Clay's 25 together, you got about 60 years of planning experience at podiums. My first dozen years as a professional planner were for the North Central Florida Regional Planning Council, where I was a transportation planner. We heard questions tonight on when is it time to do comprehensive planning? When is it time to look at things comprehensively? So we are going to be presenting to you tonight, Clay and I, as well as other professionals in our group that are licensed professional engineers who practice in the state of Florida, complete answers to your questions, and also demonstrate to you clearly that this request is consistent with not only the City of Alachua's comprehensive plan, but with the City of Alachua's land development regulations, and is aligned with the vision element of what this community has adopted in its plans. We're not asking to change the plan as much as we are asking to redesignate and realign areas on the future land use map itself to create a better quality community. So with that, Clay, slide number 1.
So this slide gives you just an overall summary of what this small scale comprehensive plan app amendment includes. It is currently a mix of community commercial, moderate density residential, and low density residential on this property. We've got a few maps to show you in just a moment. There's also an approved plan development or a PDR on the residential portions of this property with up to 275 residential units entitled. That also has a preliminary plat approval and construction plans for phase 1. So there's been a lot of work on particularly on the residential components. I don't believe any of the board members were here. The original land use and zoning changes approved by the city were back in 2022. So we are revisiting those to some degree, but I want to make it very clear that, and I'll mention it in a moment at the neighborhood meeting slides, but we have represented to neighbors. We had a lot of conversation with neighbors, particularly to the west along 188th Street back in 2022, and in our subsequent neighborhood workshops for these applications that we would honor and respect those original commitments for open space, buffering, density, lot sizes, and the limitation of vehicular access along 188th Street. So that'll be a recurring theme through this, but it's important to put out there on the record, and we did share that with the neighbors in 2 workshops actually. So this slide just gives you a quick overview of the 2 neighborhood workshops that were held and properly advertised and mailed and noticed. We had 12 people sign in for each workshop. They were very productive, sort of an open house format. There were folks from the commercial development side of things and residential, along with a team of design consultants there to try to answer questions for the public. And so those were held in the fall of last year. As you know, it does take some time to get through the process. To get to a public hearing, there's been quite a bit of work and analysis and to put applications together and get through that review process in a form that's ready for you to consider. So we are there tonight. And that was a big part of my involvement at that workshop, is to help reconnect with some of the neighbors and provide them reassurance that those commitments along the west side and 188th Street in particular and to the south would remain as promised before. So this is a timeline for the land use and entitlement process, if you will. You can see the pre-application meeting was held back in July. And so we've been working on this since then. We had 2 neighborhood workshops over at Legacy Park. Those were in September and October. The applications were submitted originally at the very end of October. Staff review has been underway since then. There have been questions and responses and comments for both this small scale map change and the rezoning application to get here tonight. And so tonight we're where the green arrow is located. That is obviously with you all, the Planning and Zoning Board, for the small scale comp plan amendment. And then the second item tonight is the rezoning. So after this board makes their deliberation and consideration, we'll go on the city commission for their consideration. One thing that's not listed in here, because it would be, if this project moves forward in the current proposed format, is that site plans will come back to this board. Preliminary plats would come back to this board and the city commission. So there are subsequent steps and stages for this project, including a lot of involvement from this board as well. So we've got a lot of handsome gentlemen here tonight. We've got a very strong design team. They're here tonight to try to answer your questions. We've got a lot of bases covered, including architects, planners, civil engineers, geotechnical engineers, and traffic consultants. So we're here to answer your questions tonight. I know this is at a preliminary level, if you will, with the land use and zoning, but we're trying to make sure that we're here to be able to answer your questions. I think we have a good feeling. Jerry and I, obviously, we're members of this community and understand what this board is looking for as far as level of information. And so we just want to be prepared to answer any of the and all questions that you have tonight. Oh. Jerry put this together, and his PowerPoints are much more elaborate than mine. So I'm sorry you didn't get to see the list of all the professionals, but these gentlemen are here tonight. Most of them. This is just an overview aerial photo of the property. The entirety of the project area, if you will, is 182 acres, but only sort of a central portion of that, about 46 acres, is under consideration with this first item tonight. And that would include a change of some of that land from moderate and low density residential to commercial. And then the remaining areas along the perimeter. See that black and white dashed line? That's the limits of the proposed land use map change under consideration tonight. All the areas outside of that are in the blue dashed line would remain exactly as they are today. There is quite a bit of commercial land use and zoning along US 441 now, and so I think what Jerry is going to walk through with you in some good amount of detail is trying to explain how we're trying to master plan this property and merge the commercial and residential uses into a master plan community under PD zoning to produce a better, more superior result than what you'd find otherwise with these urban land use and zoning patterns if they were to be brought forward in more of a piecemeal fashion. So they do have urban designations at the moment. So I just wanted to set the stage for Jerry to come forward. He's going to walk through the rest of the presentation. Thank you.
Clay's not used to my animation, but that's perfectly fine. So again, my name is Jerry Diedenbach, and I am a professional planner here. And tonight what we're going to talk about is the why. We are redesignating areas on the future land use map within this overall project site to create a better product that is consistent with the comprehensive plan in many ways. As a matter of fact, staff have identified in your staff report 29 points of consistency with the City of Alachua's comprehensive plan. So, as Clay stated, it is important to note that this is an approved project that Clay did a couple of years ago. It has a approved plan development residential on it. It has a preliminary plat, and it also has phase 1 construction plans. We are doing an amendment to realign and redistribute land uses on here. So, a way to look at this, as Carson had, This area of commercial that's being proposed is bringing a synonymous line, if you will, along the 441 corridor, whereas the existing future land use map has a piece of community commercial here, which could really do more or no more than have a strip mall placed on it. So part of the impetus behind our direction here is to create a mixed-use master plan community. And in the approval, we are actually lowering the number of residential units and slightly increasing the commercial activity in an interconnected format consistent with the comprehensive plan. The way that that works, and I know this is a little complicated, so we have some colors here. This moderate density residential area here, the beige-ish color, is reduced by about 12 acres in total, and it is spread over a little bit to here. The low density residential, as Carson stated, is actually being reduced by about 20 acres here, so we're taking units out of the residential area. The community commercial is being increased by about 3.2 acres, and the commercial area is being increased by about 30 by bringing it across the site. So an important way to look at this, because it is complicated when you're looking at the future land use map, we have a picture of the future land use map and proposed future land use map at the top and the bottom respectively. And for you all's neck, is it easier if I point the laser to one screen? Because I know Danielle is going that way. And so okay, all right. So in the future land, yes?
A question. Can I ask you a question? Just point something out while you're on there?
Yes, sir. If the chair would ask.
Please be brief.
Oh, yeah. Can you show me where the other part of the parcel is that you're bringing up next?
Yes.
Just so I can see the reference.
Yes. In totality, Mr. Chair, the blue dashed line goes around the entirety of the property. The land use amendment is confined to this area. Okay. Okay. So, and you see these small arrows. The community commercial that exists along the northern portion of the property, along the 441 corridor, is actually being brought down along the side and here to create a transitional density buffer, which is a common planning technique to decrease the intensity. Just as you go from having commercial to moderate to low to rural agriculture, we're doing that internal to the project site so that the future land use map will allow for the creation of an internal mixed-use component where office, retail, service, and other businesses can locate inside this development along the 441 corridor and do something that's very important in traffic management called internal capture. Instead of having a consistent pattern of everybody gets a driveway cut along the 441 corridor, as you heard in previous items, what we will do is we will create a limited number of access points and also build a parallel access road to the 441 corridor to reduce traffic interaction along the 441 corridor. So in our traffic study, which is the component that we used during our land use amendment and rezoning, our traffic engineer worked with the City of Alachua and the Florida Department of Transportation to come up with a methodology on how to study this project. That methodology is reviewed by professional engineers at the municipality as well as at the state of Florida with FDOT, and then the actual study proceeds forward. We've actually gone a step further than that. So not only are we working with the District 2 office in Lake City, we've been working with FDOT in Tallahassee because we know what's necessary when we do large-scale planning, even if it's a small-scale map amendment. What the facts tell us here is that there is a change, and as Carson told you in his professional staff report, and we are telling you, is that although the land use allows more, the companion rezoning that is before you tonight is actually going to take away 72 lots out of the approved subdivision that Clay has, and it is going to cap the limit of the commercial or non-residential development at 450,000 square feet. I've seen some posts out there that are asserting that there's going to be 1 million square feet of development out there. There's going to be half of a Butler out there. That is absolutely incorrect. Specifically, and why this is really important, is even though the community commercial and commercial future land use areas are slightly increasing within the project area, as the 2 residential areas are reduced and relocated inside the site and the city, the companion PD rezoning application caps the residential dwellings and the non-residential square feet below the by right future land use map classification allowances for density and intensity. So again, even though the land use would theoretically or potentially, as Carson stated in his staff report, allow a higher level, the very next item on your agenda is the rezoning that locks that down. It takes away 72 houses and it caps the residential component, and it takes and locks down the commercial also below what is allowed in the existing future land use map. And the real reason why that is very important is because many comprehensive plans and the state of Florida recognize and they underscore the fact that piecemeal development has far greater impact than a mixed-use master plan project as supported in the comprehensive plan. So we heard some comments earlier, and if you do this property, and then you do this property, and then you do this property, you come up with more intense impacts than if you do a master planned community. And that's what you're seeing, not only in our design here, but you're seeing it factually in our traffic as well as our impact analysis. As Carson stated, we did conduct a needs analysis. Inside the city of Alachua today, there are 244 residential properties for sale in Alachua's 36.56 square miles. The state of Florida has a deficiency of about 250,000 housing units. There's clearly a need for residential development in Florida. The population has increased by about 1,515 persons, 16.72% over the most recent decade. And I contacted some planning colleagues at the Bureau of Business and Economic Research, BEBR, at the University of Florida last Friday, and the latest projection for Alachua is 11,353. So it's just slightly more than what Carson had in his report. But they are the demographer, if you will, for the state of Florida that keeps their finger on the pulse of applications that are coming forward. This application represents a need for reallocation of the future land use map proximate to the city's largest jobs, employment center, downtown, and Progress Park. An important component of transportation planning is what do you do with all the trips? And having been a professional transportation planner for 12 years prior to going into private practice and now practicing across the broader spectrum, there's 2 ways that you can work on the level of service in a community. And the level of service is a qualitative measure of how much time do I have to spend while I'm driving from point A to B. You all know that as the region grows, the job centers, the University of Florida, UF Health, the Shands, VA, and Central Court System in Alachua County is like at the center of this hub and spoke. 441, 121, State Road 26, State Road 24, coming up from the Prairie, again, 441, coming in from Hawthorne, State Road 20. Everybody migrates into the city. We work, and then we go home. Some of us, like myself, I live in Gainesville, right by campus. I have a reverse commute. I come to Alachua. My level of service is A all day long. But if I try at 5 o'clock in the afternoon to get in that flow going north because I come up for a hearing or something, I get caught in that congestion. So 2 ways that you can address traffic in a city: by building more lanes. Okay, that's a physical way to make a pipe bigger. Or you can do system or demand management techniques. When I was an MTPO planner, working at the Regional Planning Council, providing professional planning services to the city of Gainesville, Alachua County, and the small municipalities, a policy decision was made in Alachua County that stated, we will not build any more Archer roads. We will not build any more Newberry roads. And they limited the roadway width to 2 lanes in each direction. Most of those arterials, the hub and spoke that come out of the Gainesville core, again, 441, obviously, State Road 26, Newberry Road, Archer Road, so forth, as you go around the clock, those are all state facilities, and they are under the state's transportation improvement program. They can't get any wider than they already are. So you have to come over here to ways to manage traffic. And in this, where you're not building, you can do 2 things. Transportation demand management by changing what attraction factors there are and where the origin of trips are, and transportation systems management, adding additional turning movements, adding traffic lights, timing traffic lights, and working on how the system works efficiently. And we have done that because both Clay and I really believe in doing our work before we stand at this podium and talk to you. So in this effort, we know Florida will continue to build. We've heard individuals tonight that say, I moved here in 2023, a couple years ago. Well, 5 years ago, they were the subject of somebody saying, I don't want another neighborhood, but now we continue to build. And people do come here, and there is enough good in the Good Life community to keep us moving. So our application really responds to the vision element and then 5 elements in the comprehensive plan: the future land use the future land use element, the transportation element, the housing element, the conservation and open space element, and of course the public facilities element. We have, as Carson stated, met the criteria of consistency with the comprehensive plan 29 times in his staff report. He cited policies, objectives, and goals that we are consistent with. We have demonstrated that we are consistent with the urban form criteria contained in the comprehensive plan. And that is true because we are creating a mixed-use master plan community that is not strip-like development, it's not leapfrog development, and it's not a pattern that is unsustainable because we are within an area where we have potable water, sanitary sewer, utilities, and we already have existing commercial land use on the property, and we have urban classifications for land use at low and moderate density. As we anticipated your questions about traffic, we follow what goes on in the city. We anticipated your questions might also be about geology. So tonight we have a professional geologist who has a very long and illustrative career here in North Central Florida to talk to you about what we have proactively done. You don't usually do this with a comp plan amendment or a map amendment, but Mr. Keith Butts, professional engineer, is here to talk to you about our efforts on that front.
Thank you. Again, my name is Keith Butts. I have over 30 years of doing geotechnical due diligence for projects. Our firm was contracted to provide due diligence on the geotechnical side for this development. We have made multiple trips to this site, done multiple reports for this site, over 60 soil borings scattered across. At the bottom there is a map showing each one of those locations, and they're not just in one side, they're over the entire property. We drilled down to as deep as 40 feet, only found limestone in one boring. The good news is, and that's significant, is when you have shallower limestone, that tends to indicate and accelerate potential karst activity. On this site, the limestone is much deeper based on the borings we've done so far. And not only that, but there's a significant confining layer above that limestone of clay-rich soils, which further restricts the potential for sinkholes. Now, I'm not going to stand here and tell you that there's absolutely no chance. But what I am telling you is that based on the 60 borings we've done to this point, in my experience, this site is suitable for the development for both commercial and residential development on this site. In addition to the borings, we did a desktop analysis. Those are typically done to look at the geologic hazards because predicting karst activity is difficult at best. The best way to do that is to look at past activity. So you, in a desktop analysis, you go through and you look at readily published documents to see what kind of activity in the general vicinity of this project exists. And that desktop analysis showed that there was a lower condition here than you might think on other areas in the county and around the city. Additionally, this site is no different than the Santa Fe Ford site or the Wawa site or the public site. The geology is the same, and those are successful projects that haven't had any issues. Additionally, there's a geophysical survey that will be done as a condition of the development during the site development phase. So we're going to go and do some geophysical work to verify what we found in this preliminary work. Now, we did a bunch of work. We said it's suitable for development, but the city brought in a colleague of mine at GSE Engineering, Ken Hill, and he reviewed our reports, and he came up with the same thoughts that it is suitable for development. I mentioned about the field work, all the borings we've done, the desktop review, and the reality is that zoning application contains specific condition where additional analysis and geophysical exploration will occur during the site engineering with the City of Alachua, Water Management District, Florida Department of Environmental Protection. So we're going to do that extra work during the site development phase. Jerry?
Thank you. So again, as I stated, Clay and I have been in this for a long time, and this is where we own our respective businesses. This is where we call home. We believe in doing things right. You don't generally do geotechnical when you're looking at a small scale map amendment, but we have already done over 60 borings on the site, and there is a site specific condition in the zoning that says additional geophysical testing will occur during site development plan processing. So let me go back to traffic for just a quick second here. In a city's comprehensive plan, as a part of the transportation element of that plan, the city looks at what new roadway corridors are created to address the future growth of the city. And in December of 2019, when the city adopted this map, you can see that there is one new corridor outlined in orange here. This is the San Falasco Parkway. The project that is before you tonight sits on the west side of the city of Alachua's limits. That roadway, which I'm turning from orange to blue because we are in Gator country, is the only roadway that is planned in the city's existing comprehensive plan. It's important to note because as the city has a comprehensive plan, that section 6 between the I-75 corridor and 235A here is predicted by 2035 to have a peak hour level of service, okay, that goes to F or fails. F is not gridlock. F is a decayed condition that has stop and go traffic. And at the peak hour, as I led to before, you have the AM peak in the morning and the PM peak in the afternoon. You can't build your way out of congestion by just adding more lanes out there. We are responsive to that fact that that will happen over time. That's why we are creating a project that is here in level of service D and C at the edge of the city, because we can do things at the edge of the city that change the trip pattern and reduce what's called vehicle miles traveled, or VMT, by creating a mixed-use development here. So instead of having to go all the way across town to get to a destination, we are bringing several destinations closer to the population on the west side of I-75 and to the populations of High Springs and other areas. So we're in fact creating a condition that will bring the origin and destination of trips closer together, which is another transportation planning technique. This map here shows you again, this is the one road that's on the city's future land use transportation element. This portion of the road has already been done. This is the parkway from 241 over into Progress Boulevard, where our offices are located. And I can tell you that many people now are not coming up to Rachel Boulevard or going up to 441 to come back to Progress Park, that hundreds of people are using this linkage because a new facility has been created to diversify traffic in the network. So in our efforts, working with the city and the county, of course, and FDOT, a condition that will be in our zoning is that we are bringing a traffic signal to this project location here. We are doing that in coordination with the Florida Department of Transportation because it is jurisdictionally FDOT's road, US Highway 441. But we know that to solve these problems, we have to look globally. We have also met with the folks that are developing Briarwood Town Center, and in the creation of our traffic signal, they are reorienting and going to adjust their entrance to be in alignment with ours, north-south, across US Highway 441. Furthermore, we are going to make that a multimodal intersection. And what that means specifically is that's not just a stoplight for cars, that is a stoplight that will have pedestrian crosswalks and ways for cyclists to get across that road, so you have then a condition where you are reducing reliance on the single occupant or multi-occupant vehicle by offering a non-motorized option for bicycles or scooters, a pedestrian option at a controlled signal with crosswalks, and we are bringing that also into our overall plan. It's also important to note, as when Carson was giving his presentation, these maps are from the Florida Department of Transportation's online traffic counts. And you can see, I know it's a little small here, that the trend has actually dropped over the last year in our section by about 1,000 trips, and then in section 6 here between 235 and I-75, it's dropped about 1,500 trips. Now, it's going to continue to grow and change over time. And if you do nothing, that's the wrong answer. So we are starting with the things that are policy approvable and conditionable in our project so that we help the project out. So that in that peak hour level of service map, we are going to do what we can here by bringing in a traffic signal, and also something that hasn't happened yet in the city of Alachua is we are going to fund a study through the Florida Department of Transportation to look at all the traffic lights along the US Highway 441 corridor in Alachua so that signal synchronization and timing can address the peak hour progression. And what that means in technical, but I'm going to be as layman as possible, is traffic moves in what are called platoons. You have the AM platoon moving into the city of Gainesville to go to jobs, hospital, medical appointments, and so forth. And then in the afternoon, that platoon leaves. Our study will enable the Florida Department of Transportation to make modifications along the corridor and interconnect the signals so that they work in a coordinated fashion like in a urbanizing area. It's on several legs of the roadway system in Gainesville: 8th Avenue, Main Street, South Main Street, Archer Road, Williston Road, 34th Street, Newberry Road. We're bringing that technology forward in our project so that it helps the city out with traffic. Our public facilities impact analysis was conducted by staff, and while there are net increases in areas, we're going to consume more water than's being consumed today, obviously. There are new homes being built, there are businesses there. We do not go through those level of services beyond a level that's acceptable. And as you will see in the zoning, there are 5 phases to the project. So this won't happen tomorrow. This will happen in a strategic, managed fashion so that the city can clearly understand what's happening phase by phase and can continue to grow responsibly in a resilient manner with the infrastructure to meet future demands. As you all know, a small-scale map amendment does not constitute a final or a preliminary development order, and therefore concurrency, as it's looked at here at the comprehensive plan small-scale level, is not a factor, but we are proactively addressing this because this is inextricably tied to an existing development that's being modified and being locked down in its threshold. These are, and I barely could get these all on one slide, the 29 points in the city's comprehensive plan and the goals, objectives, and policies that your professional staff have found that we are consistent with in our request and application. We are enabling a desirable development pattern of mixed use and master planned community. We are diversifying and increasing the city's tax base. We are enhancing the complementary future land use category distribution that's already out there in a more blended format to create effectively a town center. And then we are promoting job creation and economic growth within the city limits in a mixed use project. So with that, Clay and I are happy to be here working together. We've been doing this for a long time. When my wife, Dr. Laura Diedenbach, who is also a professional planner, left Alachua County and was their development services person, Clay took that role. Similar to my transition from public sector to private sector, Clay is now principal at EDA. We believe in this community. We live here. We own businesses. We want to do the best thing, and hopefully we have provided a presentation to you that thoroughly answers questions that you might have or that we anticipated, and we hope that you will accept your staff's professional recommendation for approval and recommend this forward to the City Commission.
Just to echo what Jerry's presented, I hope that you find that we're trying to bring some proactive ideas and solutions and recommendations for issues that are out there regarding planning through a master plan, the transportation information that Jerry's presented, and the environmental and stormwater analysis that we've done. We're trying to be very comprehensive and give you good ideas and solutions for the best use of this property in the city. So, thank you.
Thanks. And we're here to answer any questions, and if other facts need to be brought forward, we're happy to return to the podium. Thank you.
Thank you. Board, do you have any questions?
I do have one question, and I hope I'm asking this the right way, but when you were explaining this, so the requested the requested entitlement is larger than the actual built out. Is that correct? Am I saying that with the right? Where you were saying that the actual usage of the property would be less than what it would allow. Why? Why do we approve it for more than what you're actually planning to use it for? That makes sense.
Mr. Chair, I'd be happy to answer that question. Maybe Carson wants to address that too. The future land use map categories that are contained in the comprehensive plan have theoretic caps on them, or maximum densities in the form of residential, or maximum intensities in the form of commercial. When you have an applicant come forward and let's say it was just I want a land use amendment, give me some more of this, okay? You would be looking at an increase. In our scenario, we have existing land use that we are realigning and redistributing, and we are asking for a bit more. And there's already an approved PD out there for 275 homes. What you'll see in the next application is that the PD for residential, or PDR, is going to dial down and decrease the number of homes, and the PD COM, or the PD commercial, is going to actually request less intensity than what the theoretic land use classification would allow. Because that classification is spread over the entirety of the property, we are requesting numerically a lower intensity of that land use through the complementary zoning that are locked together by companion ordinances. So in other words, we get a big broad brush of a color on a map, but we're only going to use it to a smaller potential capability. And that is locked in by law through the zoning document. So while you get this much area to play with, we're telling you we're not going to use that. And your very next agenda item says, we're not going to let you use that much. You're only going to use this. So it is, again, a locking condition between ordinances and ordinance that will limit the cap on the density, reduce the houses, and reduce the commercial below what the potential is on the map today.
Thank you. Any other questions? This being legislative, could we have a motion on this item, please? Public comment comes after the motion.
After the motion?
Yes, sir. No, it doesn't come after the vote. It comes after the motion. The public comment would come after the motion. So the motion would be made, and then before the board votes on the motion, we would take public comment. Does that make sense? It's different. It's different from our previous items that we had this evening.
Why is it different now?
Well, this is a legislative item versus a quasi judicial item, and that's just the difference in the two, the way they're heard.
Mr. Chair, I'll move that based on upon the presentation before this board and staff's recommendation, this board finds the application for a small-scale comprehensive plan amendment for the JTFA LLC be consistent with the City of Alachua comprehensive plan and transmit such finding to the City Commission with a recommendation to approve.
Second.
Okay, it's been properly moved and seconded. Now we'll take public comment.
I'm going to make a recommendation that I haven't talked to anyone about in here yet. I think you should hear the zoning amendment, reserve your vote on this piece, hear the zoning piece, move, take public comments on one, because as Jerry said, they all blend together. For example, I want to know what the actual limit of residential houses are that Jerry mentioned, Mr. Dellenbach, apologize, what he mentioned, because this proposal has the potential for 427 more residential units, but it's been repeatedly said that the zoning piece will reduce that amount. So anyway, my recommendation, unless you want to handle it differently, is that you reserve your vote. You hear the zoning amendment piece because they go hand in hand. You hear the whole story and you have public comments after and you vote on both. Because frankly, knowing the way you people vote, you're going to vote the exact same way on both, either up or down. And we all know which way it's going to go. So I would hear it all together if I were you.
Mr. Chair, I can help you with that. Oh, oh sorry.
Can't do that.
Could you go a little further into the procedural of it as to why it's not
You have to
permissible?
amend your future land use map first, and then zoning needs to be compatible with that. So the first step is the legislative process that we're under right now. You can't do it vice versa.
If I can add,
please,
a land use law perspective here. When you do a comprehensive plan amendment, you have to consider at a theoretical level the maximum density and intensity that land use category would permit theoretically. And it's a planning level analysis, and it's an early warning system to the developer and to the local government. You take a kind of a gestalt of your public facilities, all those things you heard about from staff, the applicant, etc. It has to be based on the best available data and analysis, and that data has to have been compiled and analyzed in a using a professional methodology. This is all out of the statute, Chapter 163. Part of the data and analysis can be the materials that are contained in the rezoning application. That's why you're hearing about the rezoning tonight. So you have to, as Mr. Walker said, you have to consider the land use amendment first. And up or down, if you approve it, then you hear the zoning application, which has different criteria and different standards of proof. So.
Okay, thank you very much. Next person.
Thank you, Mr. Chair, board members. My name's Tamara Robbins. So one point, Mr. Chair, is that board member Highlander referenced an entitlement. She used that terminology in her question. This future land use change request, there is no entitlement to it. They are not entitled. This is not quasi-judicial. What you are doing is being asked to make a legislative decision on changing the rules. You're establishing rules when you make a legislative decision. It's totally discretionary. I'm going to read you a legal opinion of that. A legislative decision and one in which a law is made. For example, amending a federal or state statute or a local ordinance or code. The governing body of a county or municipality has broad decision-making latitude in legislative matters, which include the adoption and amendment of comprehensive plan and land development code. A local government can approve or deny a proposed legislative action or a comprehensive plan amendment for any legitimate basis. Comprehensive plan amendments are always legislative actions, right? They are discretionary. You can just not like the idea that you're increasing densities, that they're asking for a change. Again, this is where you have the power to say, no, we just don't fully understand the impact of this. Why are we changing our future land use map again? So I just want to make sure there's no entitlement here. The property owner and the applicant is not entitled to any of this. This is a legislative decision that you have the power to make with no consequence of putting the city in any sort of jeopardy of being sued or anything else. There's no entitlement here at all. And you can ask the attorney, Ms. Boyce, I'm sure she would clarify, Mr. Walker would too. Legislative is discretionary. You can just not like the idea that somebody else is coming in here and asking for more changes and whatever it is and presenting you a really great, I will, Mr. Chair, say Mr. Diedenbach is one of the best storytellers ever. He's good at it. He's been doing it a long time. But there's no entitlement here. So this decision is total discretionary. There's no entitlement. There's no risk to the public coffers of getting sued because the property owner comes back and says, we deserve this change because the rules say we deserve it. You are changing the rules right now if you vote for this. You can say no, and the rules stay the way they were. Thank you.
Mr. Chair, would you like me to respond?
Yes, please.
Okay. So the nature of the hearing we're having is legislative. You're not making laws. That's that's legislative with a capital L. We're here in a legislative policy infused forum where we're taking public comment on a motion. There are in fact standards that you have to apply to the application that's before you, and those are contained in Chapter 163 of the Florida statutes and the implementing rules of the Florida Administrative Code and the appellate law. And you don't have unfettered discretion. You have more discretion in this policy-infused area than you do in rezoning. But let's talk about land use discretion. The decisions you make up or down have to be based on data and analysis. Data and analysis is a term of art for the testimony, the professional opinions, the geologic studies that your consultant has Mr. Hill has provided, the traffic analysis, that's all data and analysis. So you can't just say, no, I don't like it. And you can't say, likewise, you can't say, well, yes, I love it. There has to be a reason grounded in data and analysis. So I just wanted to make that clarification. I appreciate the residents' attempt to educate you on the law, but we need to be careful about that.
Thank you. Next up.
May I present my public comments at this point now?
No, sir, you already made public comment.
I proposed and
That's still public comment.
okay, I'll present my public comments at the
Please do.
conclusion of the zoning.
Next up.
Mr. Chair, would you allow me just to make a quick response to the question Mr. Pappas raised?
Yes, please.
Because he's been a great neighbor and someone that we've had a lot of communication with. So the land use map amendment, the change would go from a maximum of 275 permitted residential units in the residential area down to 203. So it's a reduction of 72 units. So that's actually very, very clear in the map change for the residential. The current PD zoning on the property allows 275 units, and the proposed PD that would be your next item would be that 203. So it's a reduction of 72.
Can I ask a clarifying question?
Please make it quick.
No more than 202?
Please come up. Please come up.
Yeah, no, I mean,
Yes.
Just so that you know, I have worked with Clay and his team and Sergio, Mr. Swager, for 4 years, long before any of you were involved. I've been working on this project since 2021. These folks have been fantastic people to work with, ownership, consultants. You all should be very proud that you have these kind of people working with you. They've been fantastic. And I haven't appeared before you, but I've appeared at every hearing on this matter prior to this new change, just so that you know, because I didn't get a chance to introduce myself more fully. But the zoning change will cap it at 202?
203.
203. But what's the
And
potential
doesn't matter.
by changing because we're changing, because as Carson said, Mr. Crockett said, 427 units.
Mr. Chair,
could
we
be
don't want to
potential.
open the door to cross-exam.
Yeah, this is going a little further than a quick answer. So is there any other public comments?
I'm Bill Smallbine, and I wanted to address a question to Mr. Dienbach. Am I pronouncing your name correctly, sir?
D. Denbach.
D. Denbach. Apologies there.
Sir, if you'd address your question to the chair, we're not in a quasi-judicial.
Oh, no, I understand. I was going to say that I enjoyed the presentation. It looked like from the slides that there was a lot of thought put into what to do about traffic, given that 441 is already in the situation that has been discussed before. I saw one item on the bottom of the slide that talked about one of the ways to deal with traffic was to live, work, and shop in the same area. Now, this experiment has been tried in Viera in Brevard County and in Fort Lauderdale in Broward County. The common denominator between both examples is the people who can afford to live in these areas do not work in the jobs that are available. They're usually minimum wage jobs, which means people have to drive from other areas, adding to the road congestion just to get to work. And my question is, in what area in the state of Florida has this concept ever worked the way it was presented or intended? Does anybody have any examples?
Mr. Chair, I'm happy to take the questions and then answer them all, because we do have data and analysis to that fact, and that's a wonderful question.
Okay, thank
happy
you.
to answer that question for you
Look,
all.
okay, let's go
take
through the
notes.
comments and we'll come back to it.
Mike Owen, I live in the neighborhood. Thank you, Chair and board members, for listening to us today. And Gentlemen, you did a beautiful presentation, but how dare you think that these board members are so foolish to listen to you tell them over and over again that your new plan is better than the old plan. That's for you guys. That's not for us. He keeps saying it, keeps repeating it, repeating it to you all like you all are, and he's very eloquent, very nice the way he did it. But he keeps telling you that this is better. And the thing is that it's better for his client that's going to make more money putting more commercial in there. We don't want more commercial in there. And they're going to make less homes, but they're going to make them on 1/4 acre lots instead of 1 acre lots. We live in the neighborhood. We have 5 acre lots. We can't make them any smaller. And the pre-approved plan was fine, but changing it, no, it's out of the question. They're trying to pull something on y'all. Please vote it down. Thank you.
Thank you.
Good evening. My name is Finton Vargas. I live on 188th Street. Data analysis, reports, are those the only criteria that you can make your vote on? Or is the voice of we the people, what we want you to do, considered in this particular
If you have
issue?
data and analysis testimony, absolutely that can be considered from a lay source. This is public comment, and you are, of course, permitted to address your concerns to the board. What they can use to legally make a decision is maybe a different matter than what you have in mind. I don't know.
Right. No, I'm just saying the voice of we the people. We are here asking you.
These are not political decisions. We don't make
Right.
these decisions based on, show of hands or likes and dislikes.
Okay. Analysis. There are some promises to make studies in the future that haven't been done. If somebody wants to bring something to you to make a vote on, they should have that already. They should have had that already. They've had several years. I've been here as long as Mr. Pappas with this new project. We heard it was going to be 250 homes. Now we're hearing 400 something extra homes. Geological impact is something that is being considered to look at in the future. How come it hasn't been brought up now? How come it wasn't brought up before they brought it to you? What has changed since this was approved begrudgingly before till now? Is it some kind of change in the property that they need to make more money, or is there some change that has forced them to do this? Consider that as well. And we'll have more comments in the next item. Thank you.
Thank you.
Hello, Deborah Havlick. I looking at the data. This is hypothetical. He's talking about like you're going to contain. I go past the tech city, and they're supposed to like work there and have their little time restaurant. I like their food, the time restaurant, but I don't see it getting used very much. Those people are always trying to get onto 441. They don't just stay there. They, like all these people. You can say you're going to have some commercial things for them to do there, but they're all going to be going to Gainesville and the High Springs and Alachua. They're all going on to 441. So it's hypothetical, and reality is much different than hypothetical. So the data is not based on something real. So you really have to consider reality, I think.
Hi, Jared Fletcher, resident of Alachua. I've sat here for 3 hours and I've listened to a lot. I've listened to a really well thought out presentation, and it's better and more eloquent than probably anything I could say tonight. But I'm a fifth generation Floridian. I'm a fifth generation resident of this county, and the changes that are happening here are having an impact. They are. And we can't just turn a blind eye to that. You guys have a tremendous responsibility, but it seems like most of this almost feels like a dog and pony show. Public comments are taken, but you guys have already made up your mind. And that's fine. That's just the way things are sometimes, but it's not making us as residents happy. It's not improving our quality of life. It matters. It matters to people like me. It matters to someone, who's been in this county, who's generational in this place, and to see it change the way it's changed. It doesn't mean that growth isn't going to come. Growth is always going to come, but we can be smart about that growth. We can, and we can do it in a way that is in alignment with this community that has a rural heritage. And I think that y'all need to remember that this community has a rural heritage. Don't forget that. Thank you.
Thank you.
Hello, Mr. Chair, Soria Lindberg. I would like to remind the board and the public, last year, May 2025, Ms. Boyce was not here to give us extra advice. The Planning and Zoning Board turned down this exact same similar thing. They turned down a future land use map, and that was for the extra residential stuff on Tomoka. So it's literally possible. No one's going to get in trouble. And what they did is they deferred it back to staff, so it didn't go away. So right now they have and to address the 1 million square foot fact, that's from table 2 of the staff report. I'm going off facts that I see, black and white, what's the maximum. So right now they have 182,000 square feet of available commercial space. Let them have it. It's approved. They're literally here asking you to change the land use. You can say no. It's not like putting a Chipotle on commercial. They're allowed to put Chipotle on commercial, but they don't have to do this part here. Their client spent lots of money on it. So I just want to remind you that this is not just another development. It's a major land use change. Let's see. If you're going to go from and trying to mitigate the traffic too, I made that point as well. And then asking you to consider the rezone, but that's not here. You're not voting on a promise, and you should consider what's legally available and the maximum thing to see. And I just really want to emphasize, you can say no. You can say no. You did it last year. You can do it again. They can have the 182. They can come back and say, okay, well, we want a different number. You can say that. And the nice road is nice, but it's the cars going there. It's the people wanting to go to those stores. 182,000 square foot, that's the size of a Target or Walmart. 1 million is 7 or 8 of those. And they can say that, but if they can legally max out, why not? Also, having a town center, what about our beautiful downtown Main Street? We're working so hard to help the Main Street. We're going to have a town center there, a town center at Briarwood. And the last person said smart growth. How many times have we heard smart growth the last 30 days? Is this smart? Is it responsible? You're changing the quality of life for everyone in the region. It's not just me. I can see my house from the map of the neighborhood meeting. So again, beautiful presentation from a very respected professional who lives in Gainesville. I could walk to this development if I wanted to. It's not safe right now. So please remember that a no happened before. It can happen again. They still have their PDR. You're not changing their PDR. And they can come up with a better idea that's aligned with our community.
Good evening, Rudy Rothsiden. I believe in you guys. I don't doubt you. I've seen you out on the streets. I've spoken to you. You've heard the people in our community speak to you. We just had an election. There's disappointment in the development that's going on in the city, in the way it's going down, the special interests. I believe I've heard each one of you speak very clearly about misinformation being presented to you. And I believe you can decipher that. We've heard a lot of how tall and good looking Mr. Diedenbach is and how well he speaks, and he does. He presents a great picture. And what do you say? This is gonna make us better. We're gonna make this what you want, we need. You drive these streets, you see the traffic, you see the change in our community from a rural community, a small town community. You know what? I don't want to move to South Florida anymore. It's coming here. Come on, it's here. We're there. We're on that precipice of changing our lives. How you want to call a good life community? We're on that point. These are decisions that change our lives, that change what our city is going to look like. You know, the city center is downtown Alachua. We've done a lot to revive it. It still needs a lot of work. Is this type of stuff going to add to it? No. It's going to pull away from it. It's going to add more traffic. You're going to you have F rating there. It's just down the street from it. You have more and more people going on their back roads, congesting, traveling. How many trucks are going up and down that road? I mean, it's you have the power, you have the vision. You know what's going on right now. Please think. Thank you.
Thank you. Anyone else?
Good evening, y'all. Brian Bisher. I have a problem because I can only see you guys with my glasses, but I can only read my notes without my glasses, so I apologize for that. Isn't this really just piecemealing? I mean, it got approved a few years ago with a certain density, and they have those entitlements. So isn't this just really the next step of piecemealing, which is to increase the density? And I know, they've mentioned the campaign and everything like that, and how people were talking about smart growth, and a lot of the vile nature of social media was like, don't make Alachua Gainesville. And isn't that what this is? Aren't we just Gainesville-fying Alachua with this development? Increasing the density, increasing the commercial. In the past, I've stood before this board and talked about future land use map changes relative to comp plan changes, and have been told I can't talk about zoning, right? I was even told once, hey, we're just changing colors on a map at this stage, right? And so which is it? Are we talking about the zoning or are we talking about the comp plan change? Before you right now is the comp plan change. You have a meeting next week about the comp plan, right? Why is it that every single meeting before the city commission is a comp plan change? How is that planning? Right? That isn't planning. You're just needling it, piecemealing it, death by 1,000 cuts. So data, right? What do you hang your hat on this? Right? Well, it's a piecemeal. Yeah. Hey, they're talking about a million square feet. That does increase the overall possible density by 427 units. Traffic studies, hey, they are just that. They're studies, they're projections. Traffic studies were done, and yet we still have level E. Right? So you can do the math. You add more traffic, you get more of a problem. You add a signal, well, wow, you're just going to add more traffic. This is a growth-inducing impact as well, because now Briarwood Town Center is going to come to you and say, hey, you got commercial right across the street from us, right? It only makes sense to make it commercial on this side too. So growth-inducing impact. I'll just read from the GSE report. Geotechnical engineer qualifies both reports as preliminary due to the preliminary design state of the project etc. It may be necessary to perform additional geotechnical services, including additional test borings once the structural location stormwater management system are available. You've denied projects based on that alone. Thank you.
Thank you. Anyone else?
Mr. Chair, may I be heard?
Yes, sir. Can you come to the podium?
Members of the board, Mr. Chair, my name is John Ramsey. I've been an attorney in the county for nearly 20 years, and I can attest that I drive, well, I don't drive obviously, but I ride on 441 at least twice a day, every single day, and the impact that urban sprawl is having from High Springs, where I live, all the way to Gainesville, where I used to live, is overwhelming. And not to mention the in deciding whether or not to change a zoning area, some of the things to consider are also not even the human elements, but the impact that it will have on the environment, such as animals, wetlands, things like that. And I would simply ask you all to take that into consideration when you vote on this issue. And of course, bearing in mind that you've been presented with one data analysis, and of course, there could be hundreds of other counter analyses as well. So I would just ask you all to take those kind of things into consideration when you vote on this issue. Thank you.
Thank you.
Good evening. I was listening with interest to all the data presented, and Ms. Boyce made a point about the data. So traffic and all the data was interesting to me. But I have a question like, is there any financial or quality index data or any of that has been kind of considered or looked into, that how it kind of adds the value, means financially, maybe city, but what about the residents? I'm not sure, like, how those metrics are there, but is there those data or studies being considered as well? Thank you.
Sir, sir, could you say your name again, please?
Oh, sorry. My name is Umesh Sharma.
Thank you.
Mhm.
Any other comments? All right. Anyone from the board wish to?
Yes, Mr. Chair. So as I understand this, this has already been approved, right? And did I hear tonight that you have a preliminary plat? This is probably a question for the applicant, I guess. Right. May I ask, where are you at on your timeline for that preliminary plat? Is it going to expire anytime soon, or is it further in the future, or what? Right now, today.
It is a valid preliminary plat. I don't have the exact expiration date, but it's
Mr.
year
Chair,
or two.
when was the preliminary plat approved? I think maybe
Within
our
the
planner
last
can help us.
1 or 2 years.
Well, I know
And then
there's a
construction
timeline
plans.
that clicks, you know what I'm saying, once that preliminary plat. So I'm just trying to be very forthcoming. I'm wondering, is that what's, aside from a financial or a business decision, is that what is driving a timeline now? I guess that's more that's not a question, so forgive me, but where are we at on the preliminary plat, please? Thank you, Mr. Carson.
Mr. Chair, I don't have the exact date, but I know the ordinance number started with a 22, so it would be fiscal year 2022.
Okay. My guess is timeline for preliminary plats, 18 or 24 months, Mr. Crockett?
Mr. Chair, when developed in two or more phases, a preliminary plat is valid for 3 years. The latter of 3 years, plus then an additional 12 months after approval of construction plans for a phase. And then you do final plat and that gets added. And then, of course, there's also extension requests as well as statutory executive order extension requests that aren't up to us.
Right. So, hang on just a second. Sorry. So, have any of the phases with regards to preliminary plat been approved at this juncture?
Mr. Chair, construction plans have been approved for phase 1, but a final plat has not.
Okay. So I think that's important to keep that in mind, right? Where are we at on the construction plan process? You said they've been approved, or
Mr. Chair, yes, for phase 1 of the preliminary plat, the construction plans have been approved.
and roughly what date was that?
I don't know off the top of my head on that one.
Okay. All right. Well, for me, that answers questions. I think we've got some timing issues going here. Again, just my personal observation, not entering a fact. This is all legislative. And so that's it. Thank you.
The applicant like to speak again?
Yeah, real quick. Yeah, we do believe that we have quite a bit of time still on those permit approvals. So the request before you tonight is not due to concern of expiration of those. It's to revisit the project on a larger level. And if it is approved, a new preliminary plat would come in to the city. I would like to just try to provide a response on the question of the residential density per Mr. Pappas's inquiry. The land use map we created very intentionally, the future land use map for the residential areas, to carve out acreages that would provide a density to the exact number that we want to build in the residential neighborhood. And right now, the future land use map has 275 units max. This map change, if approved, would cap that at 203. So that I can make very clear that the map change would reduce the number of potential residential units by 72 in the residential areas. Part of what's a bit confusing is city staff in their diligence. They did note that fairly recently the city has changed their regulations to allow 15 units per acre in commercial areas. And so some of those big numbers that you saw in residential are because they are allowed. So that you could have hundreds of apartment units in commercial areas, but I can tell you definitively that the zoning application would eliminate all those. It would only be 203 single family detached units. That's what we're putting on the record before you. That would also go into a PD agreement between the landowners, developers, and the city as a legal document to ensure that that was the case. It's not just a matter of an easy zoning change to change any of those entitlements. I hope that helps provide a bit of an explanation on the residential side.
Thank you, Clay.
Thanks.
Okay, and I too am the one that need the glasses to see here, but then you're kind of blurry to me, so I'll do that. So I'll do my best here. I did take diligent notes of each of these items, and I'm going to not address them in order per se, because I think that there is a logic to the way the questions were can be answered to you that provides you better direction. And as consistent with the AICP Code of Ethics that Clay and I find, our number one responsibility is to the public interest. So there was a question by the gentleman who returned to the mic, I think Omish Sharan. And again, I have a very difficult name to pronounce. Please excuse me if I'm not getting the pronunciation correct. The factors that must be considered, and I would certainly defer to the two attorneys that are sitting here. The factors that must be considered in a comprehensive plan amendment are defined in the comprehensive plan itself. That is the city's effective Bible, if you will, on the strategy for growth management. When map changes come into play, such as is requested tonight, we are requesting either small scale, under 50 acres, or large scale, over 50 acres. We're moving things around in an aggregate form that's less than 50, so this is a small scale amendment. But we are doing that in direct response to the written words of the plan. So in other words, we are not proposing changing the direction or the law of the land of the comprehensive plan by promoting text amendments. We are proposing map amendments so that we are more consistent in the development form with what the city's vision element, future land use element, transportation element, conservation open space element, housing element, and public facilities element tell you that you must do. So we are bringing more consistency into the plan as opposed to, with all due respect to my colleague here, a homogeneous subdivision on 441 with a strip mall in front of it. We're building a master plan community. And early on, there was a question about, are there examples of where this has worked? Many of you here in tonight's meeting know of Hale Plantation. Hale Plantation started out as a development of regional impact, introduced elements of new urbanism into its core, and created the Hale Village Center. And the principle there was, and I hear it articulated by other commissioners and other communities, I want the woman who owns the cupcake shop to live in the neighborhood where the cupcake shop is. You see that in Hale because there are veterinarians who live on top of their medical practice. Hale was the first one that I can think of that worked here in Alachua County, and it took time for it to move along, but it has matured over time. Tioga is another good example of that. There was a question that was put out there, but who is this for? Well, Hale has doctors, dentists, veterinarians, lawyers, not just blue collar or minimum wage employees there, but they have employees of all level, down to the level of the person who's probably stirring the batter at the cupcake shop because they may be a high school student. It's important to note that because from a planning perspective, and I appreciate the compliments, sometimes sideways, that we hear when Clay and I stand here, that we are eloquent in what we say or give a good story. We're not pitchmen, we're professional planners. And if we keep doing the same thing that has been done in Florida, we don't get a different result. So after Hale, Tioga came in, and you all know that there's doctors, dentists, financial analysts, financial managers, banking professionals, design professionals, real estate brokerages in there, and there's cookie shops. So that mixed use form is really starting to work well here in Alachua County because other developments have adopted that too. Arbor Greens, there's attorneys at the very front of that, and there are other professionals. So yes, this does work in Alachua County because we have a very special sort of modality here. The county commission and the city of Gainesville are very multimodal focused on bicycle, pedestrian, transit. So we are proposing to take a homogeneous subdivision with a strip of commercial along 441 and turn it into a place that will capture trips. So someone leaving High Springs may not need to go as far, and we reduce vehicle miles traveled, and we create another economic hub or an activity node in the city. Mr. Vincent Vargas had a question about the voice of the people and data analysis and this being not practicable. Should the studies, have happened earlier? And what I have to say about that, and again, the attorneys can tell you that there is a definitive process in a legislative item and a quasi-judicial item. We have met the process to be here tonight to ask you for a map amendment on the plan by having consistency with the text of the plan. As was asked by Ms. Havlick, Deborah Havlick, it's not all hypothetical. The data is based on something real. The traffic information that has been brought forward that shows we will have a lower number, and our work with the Florida Department of Transportation in Lake City and Tallahassee is not hypothetical. We have our professional engineers working with the DOT's professional engineers to come up with strategies to address congestion and start to relieve that issue and look at how the city functions as a whole. There were questions in there about you can turn things down. That is a fact. But we have presented the adequate amount and gone beyond that by also bringing geotechnical information. That's not hypothetical. 6 test borings were created on the site, reviewed by 2 professional engineers, and then a third by Mr. Butts in his office, then a 4th geotechnical engineer, and they said this area is consistent with the surrounding context, pointed to other developments, And still, we're going to have conditions going forward that we are voluntarily agreeing to do more testing as the site plan matures. Obviously, since they have a preliminary plat and they have construction plans that are moving forward, they are working with the Water Management District, the Florida Department of Environmental Protection, and then that's under the guidance of Mr. Sergio Reyes, who's in the back of the room, maybe still here. There was a question or a statement about misinformation being presented, and I want to talk about the fact that when we are making decisions like this, okay, we are not forcing a decision upon you. This is a choice that's based on data and analysis that's produced inside the framework of the process, and it is brought forward with definitive studies. And it is, again, inextricably tied. So I really appreciate Mr. Pappas's comment, because if you give us land use, and then when we get to the next item, you give us zoning, that is the way you tie the two together. So that there's no dog and pony show. There's no shady thing happening or no shell game here. These two things tie together perfectly well. When talking about 441, I was addressing Mr. Ramsey's comments here. I too drive it every day, twice a day, sometimes 4 or 5 times a day, actually. And we have a site that is a commercial tree farm. It is an agricultural use of sorts. It's not producing food crop, but it's producing ornamental horticultural vegetation. So upon this site, we're going to go from a site that has obviously agricultural use, water consumption, pesticides, herbicides, fertilizers, and things like that, to something that is much more highly regulated, that is going to be permitted through the Water Management District, through the Florida Department of Environmental Protection, and of course the City of Alachua. And there are standards and protections that are in place for that. This land use is only possible, and that locking down of that capacity through the enabling zoning, that is your next item. This is absolutely not piecemeal. The reason we're doing this is because before, again, with all due respect, doing a subdivision next to a couple pieces of commercial isn't holistic. This is holistic. We cannot continue to apply the same answers to the problems that we have with congestion and water and our development program if we don't do something different. That's why we're here, to create a better product. And I would like to remind you of something that I've heard so many times. Saying no to one thing is saying yes to something else. And when you have a professional staff that have given you 29 areas of consistency with a comprehensive plan, saying no to this says yes for those parcels to develop one at a time in a piecemeal fashion, seeking the maximum that you can get out of every parcel, as opposed to coming in with a master plan, capping that number below the allowable theoretic maximum, and promoting it as a community. So I hope that answered all the pieces in there. I tried to get every orange box and every comment that was there. Thank you again.
Thank you. Board, do you have any other questions?
Mr. Chair, I just had one clarification. It's just me thinking out loud. Obviously, this will require an ordinance, as with the next item. And so in that regard, we are not the final decision makers. Is that correct? Right. So what
Correct.
decision we make is simply, an individual member's thought process. And then the other thing I just need to clarify, this property is currently under a PD ordinance. Is that correct?
Mr. Chair, a portion of it is under a PD ordinance, the residential land use area, but the commercial area is not. It's just straight commercial.
Okay. And so I think I heard that there was a preliminary plat, which is obviously residential, along with construction plans.
Yes.
So how does that already gone piece, for lack of a better term, jive with the current PD ordinance, which, I'm saying would migrate into something else? Can you help me with that part?
Sure. Yes.
The PD rolls it all into one.
Okay.
Yeah, it
It
all
would-
becomes a part of a plan development.
Yep. The PD agreement and the PD master plan would all be amended as part of the zoning process.
To take
and
everything in.
It would replace the one that's in there now.
All right. Thank you.
Anything else from the board? All right. It's been moved and seconded, and it's time to have a vote. All in favor? Aye.
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 No.
And chair votes aye. Motion passes 3-1. Yes, 3-1.
Mr. Chair, before proceeding to item I, staff would like to request a 5-minute recess.
So be it.
Thank you.
Thank you.
Because there's no way they're voting on one yes and one Sam. They want to straight. We're not going to do
Are you ready to begin?
I'm ready, Mr. Chair, if you want.
All right, let's reconvene the meeting and proceed with item I.
All righty. Good evening again, Chair. Welcome back. Board members, Planning Director and City Attorney, Carson J. Crockett, Principal Planner for the City of Alachua. My resume is on file in the Office of the Deputy City Clerk. This is a quasi-judicial item, so if I could have Brenda come up here and swear us in.
Everyone that wishes to speak on this matter, please stand and raise your hand.
Do you swear or affirm the testimony you're about to give is the truth and nothing but the truth?
I do. Well, we're starting with the applicant's presentation on this one. Yep. Okay. I've been sworn in. This hearing is a quasi-judicial hearing, application number PR 26-0002, known as the Farmlands Commercial Site-Specific Amendment to the Official Zoning Atlas application, sometimes referred to as the Farmlands PD application. The item is a request by EDA Consultants Incorporated and NV5 Incorporated together as the applicant on behalf of 4 property owners, AYLA LLC, First Coast Road Rangers LLC, Jack Small Engine Repair LLC, and JTFA LLC, together as the property owners. The application proposes the rezoning of an approximately 182-acre parcel from community commercial, commercial intensive, and planned development residential to planned development residential and planned development commercial. As provided for in the city's land development regulations, the applicant will have the opportunity to present first. Staff has not received any requests ahead of time for affected party status, but there may be some here, and staff will present last. Before I leave the podium, I would just like to incorporate by reference my previous presentation as staff into the record of this hearing.
Thank you. Mr. Attorney, would you like to poll the board, please?
Yes, sir. Are there any ex parte communications?
No.
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 No. Thank you.
All right. Good evening, Mr. Chair, members of the board, Mr. Attorney, Madam Attorney, Mr. Planning Director. Again, my name is Jerry Diedenbach, NV5 Executive Vice President and an AICP Certified Planner. We are here on behalf of our applicant tonight.
And I'm Clay Swager with EDA Consultants, also a certified land planner.
And we would obviously like to incorporate all the content of our previous presentation into this so that you have a holistic plan, as we've talked about all night, and all that portion of our application materials, our testimony that we provided, the data and analysis, and of course, our PowerPoint slide deck and application materials. So this is going to look a little familiar, but there will be portions in the center that deal specifically with the zoning component. So Clay, your lead, buddy.
So as we did discuss briefly early on, this is a rezoning request. It's a companion application to your recent deliberation on the comprehensive plan future land use map change. As Carson indicated, this is a rezoning from community commercial along US 441 to PDCOM, which stands for Planned Development Commercial, and also an amendment to the PDR PD zoning. And so the limits of the PD residential area is being reduced and to match with the PDCOM and the commercial land use map, which you have recommended for approval. This is an effort to bring the entirety of this 182 acres into a planned development as a unified master plan development. And we will go through the details of that PD in just a moment. These are the same slides just to indicate we did have 2 neighborhood workshops. Those were the same workshops where we proposed and presented the comprehensive plan future land use map amendment. And those occurred in the fall of 2025. And there were 12 community attendees that registered at those meetings. This is that same timeline. Actually, it's slightly revised. This is for the rezoning. As you can see that there was a pre-application meeting held in July last year, the 2 neighborhood workshops. The submittal was made at the end of October of last year. After that, commenced the staff review. And we are here tonight before you as the sitting as the Planning and Zoning Board to consider this rezoning application. After your considerations are complete, we would go to the City Commission for their determination as well. And as I also mentioned before, this project will have site plans, it will have preliminary plat amendments and plats. 2 of those 3 will come back to this board for additional review and subsequent steps. As I mentioned before, we do have our design team. There are some folks here that may be able to answer some questions along with Jerry and myself on the zoning. We do have architecture representative as well, and there are some PD standards and so forth regarding building design, and I know that he would be happy to answer any questions that you might have. This is a context map. It does show the entirety of the 182 acres in, well, it's sort of a dashed line. It's hard to see. But all of this would be placed into a unified plan development. The PD, which you'll see in just a moment, does have 3 main access points, ingress, egress onto US 441. That central access point is where a proposed signalized intersection would go at the as part of this development approval. That's about 1,500 feet east of 188th Street, just as a point of reference. In addition, the emergency access only for police, fire, emergency vehicles would remain as placed in the PD currently. That was an important consideration in 2022 with the neighbors on 188th. That will not be a full access point, and that issue will remain settled and will not change. This is the future land use map that you have just recommended for approval. The smaller area, you do see the approximately 46.7 acres, which is recommended to change to commercial and community commercial is shown. There are some moderate density, low density, and more moderate density residential land use designations that I just pointed to in the brown and the yellow. As I did mention before, that land use map was intentionally split between moderate and low to have a cap of 203 residential units. The land use map would not allow any more in those residential areas. The PD that we have.
Excuse me. Gentlemen,
Sure.
If you'd like to have conversation, please go out to the lobby.
Okay.
Sorry, sir. Please
No
proceed.
problem at all. The PD that we are presenting to you represents that as well. Single-family detached units, 203 total within the PDR. This is the existing zoning map, which you can see the sort of lime green color is the PDR that's in place today. The land use map change to commercial would carve into this central area, and as such would change that the dark green would go to PDCOM, Plan Development Commercial, all part of one master plan. I will point out too, going back to the existing map, as we did discuss, there is quite a bit of existing commercial land use and CI, commercial intensive zoning along US 441, which if left in its current condition would result in smaller scale, segmented, more piecemeal development. All of that's being brought in to the PDCOM area and part of the umbrella of our master plan. This is the zoning master plan. I know you do have it in your backup material. Again, The entirety of the project is approximately 182 acres, outlined in pink. The PD-COM area is identified as Area A. That is approximately 48 acres in size. Area B where the single-family detached units would go. We have color-coded some. These would have a minimum size of a third of an acre in the orange, and then a half acre in yellow. That was part of the PDR agreement that's in place currently. And the remainder of all the residential areas have a minimum of 10,000 square foot or a quarter acre lots. So they're a little bit larger than some other residential developments you've seen come into the city. The area identified as C here, and here would be common areas, landscaped, and stormwater retention areas. So that is the overall layout of the project. The residential area, as I indicated, those lot sizes would all remain the same as what was in actually is currently in the PDR. A frame of reference, you've got about a quarter of a mile from 188th Street to the commencement of the PD-COM area. The signalized intersection is shown here, approximately 1,500 feet from 188th Street. There are many conditions of approval that are indicated in this PD document. Be happy to go through any of those as you see fit. As I mentioned, there are requirements for additional geophysical analysis as part of this PD above what is typically required in city regulations. And I think at this point, I'll pass it to Jerry to continue the presentation. Thank you.
I like this. Sometimes I do this down at Alachua County with Jerry Brewington, and it's the Jerry and Jerry show. But tonight it's the Clay and Jerry show. So we're going to have to trademark that one. Again, Jerry Diedenbach for the record, Executive Vice President, NV5, and a ICP certified planner. I want to back up on one slide just for a second because there's another component that we did not talk about in the land use because it wasn't germane at the time to talk about that. When you look at the project boundary here, see this area where I am outlining here with the laser pointer that touches obviously 188th. There are some additional parcels here that were east of the existing approval. The zoning that you are seeing goes beyond the land use and the original approval. So Clay stated it, but I just wanted to make sure that you understood that because it's important when we talk about that piecemeal development. Like there's a small engine repair here, there's Florida Road Rangers, the FDOT contracted vehicles that come out if you dial star FHP. So there are some additional parcels here that are already with commercial land use that we are incorporating into our zoning and thereby locking those down too in the big picture of what could potentially be happening there. So as Clay stated, his PD res or PDR that used to go all the way up there accepting that little bit of community commercial is being reduced. So now you know how it goes from 275 down to 203, right? This PD-COM is incorporating parcels that weren't previously in his, so we're taking additional, I would say, undesirable future outcomes of piecemeal developing, and we're incorporating it into our master plan too. So that produces a better result. Our distance from the intersection of 188th to the property corner is about 1,000 feet. There are commercial intensive parcels on the corner here that are not a part of our project, and our traffic light is about a quarter mile, about 1,300 feet east of 188th. We have coordinated that through the city and the Florida Department of Transportation so that our access will interconnect between the two pieces. So here is the PD, and you can see those are the additional pieces that weren't in Clay's original approval, but now will be zoned in here and further capped down lower than their potential land use. I really liked the fact that we did 2 neighborhood workshops at the rec center, and Clay and the team's proposal there was not to present in a classroom type format, but we had boards around a room where people could go station to station and talk about specific things. And I thought it very honorable that Clay and Sergio and EDA upheld everything that had been promised before. The only emergency access to 188th, the larger lots here and the larger lots on the east side, because those were important I would say communicated covenants, if you will, and then memorialized in the zoning for the surrounding neighborhoods. And we want to be good neighbors. So in here, our request is locking this down to 450,000 square feet of non-residential. You will see in your staff report something that actually confused us a little. It says 454 in there. That's because there is an amenity center that's considered a non-residential thing. So the pool, clubhouse, and stuff for the residents, that's technically non-residential. So the actual total of what we're doing here in the PD COM is 450. Clay will have about 4,000 there for the clubhouse, pool, and pickleball. There's got to be pickleball. It's 2026. So our PD COM area has a little bit more of a detailed plan. When I talked during the land use about interconnectivity, I want to go into greater depth here because in a zoning item, what we are doing here is now bringing that land use color on the map forward to an actual sort of preliminary site plan. First and foremost, as I stated, about 900 feet from the intersection of 188th is where the property starts, right here. So our first entrance will be here. About 1,320 away is the signal that will be coordinated with Briarwood Town Center to the north that will also contain non-motorized vehicle, pedestrian crosswalks and all. And then we'll have another entrance here. So instead of piecemeal development up and down the corridor with every parcel getting a driveway, we have consolidated our traffic access consistent with access management standards of the Florida Department of Transportation, who are the jurisdictional entity on this road, into 3 entrances. When you turn in to this development, you can go to your residential home, which is buffered from the commercial or non-residential area by stormwater and landscaping. But we've also stubbed that road right to the edge so that a parallel access road to US 441, which I'm highlighting here at the north portion of the map, can exist from property edge to property edge. We're not building another Archer Road or Newberry Road. We are building a facility that allows parallel access or a enter, shop, dine, go to work, go home, and not have to rely back on US Highway 441. In addition to having the pedestrian access here, another component that's being worked into this master plan, and I'm going to back up one slide, is there is an arrow here. If you live in the neighborhood in this portion, and you're like me, and let's say you're 14 years old and you're the busboy at a restaurant, and you fill the waters and carry the ice and bust the tables, if you live in this neighborhood, you can get here without a car. You can walk down the sidewalks, come to a multi-use path, and connect to a job. So there's jobs there for the person starting out as a young person, or let's say you lived in this house here or here, and you were a pharmacist or you were a dentist. You can walk to work, something that hasn't been seen before. That connection is reflected right here on the master plan that comes up in between these 2 non-residential or commercial blocks, and that sidewalk system interconnects. And we have defined all of the street cross sections to include not only vehicles, but landscaping, lighting, and pedestrian pathways that will work throughout the entire development. So it's internally connected in a multimodal fashion, and then it's externally connected to future development, and if these parcels develop in the future, there's future development connections to the east, which is consistent, again, with the comprehensive plan, and it promotes a multimodal interconnected transportation network in the city of Alachua. Again, this site, the signal here, is about a quarter mile. That's the new signal coordinated with Briarwood Town Center. This is the multi-use path to the neighborhood, and we're doing some additional new cool things in this. So we have one request of you that derivates from the code. We are requesting, consistent with best management practices, and I apologize for that not being white. I did send another copy of the slide deck over, but we got this one in here. When we looked at this program in the neighborhood and the commercial and how this works here, these buildings will end up being about a quarter of a mile away from US Highway 441, and then there's the access road. When looking in this photo rendering from 441, based on the landscaping requirements of the city of Alachua, you can see like here is a business here with outdoor dining, trees. It will be very difficult to see the actual name of these buildings or these tenants here. So we are asking for one derivation from the code to allow more square footage on these signs here so that they can be in a proper scale. We are doing that because we researched best management practices, and one of the guides that we used was Robert Gibbs. It's the Bible of New Urbanism and Principles of Urban and Retail Planning and Development Design. This was the same document that many planners have used when creating urban residential and urban commercial retail spaces to ensure that visibility exists and that connectivity and those principles are added. And you can see the grid. We've superimposed portions of Briarwood Town Center here. This is already developing as residential, but we've superimposed the grid of like their connections to show that we're coordinating across the street to further alleviate future issues. I won't go through this point by point because we're incorporating from our land use discussion these elements. The needs analysis has been met. The application responds to multiple components expressed in the city's vision element. The urban sprawl analysis has been conducted. Again, staff has identified 29 areas of the comprehensive plan that this is consistent with. We are consistent with the urban form criteria as previously stated and as brought forward here in this slide. And in this master plan mixed use design, we want to show you and talk about a couple elements here. From the top of the slide here is US I-75, another federal highway. Here's US 441 going from Alachua westerly to the city of High Springs. So we have Publix, Santa Fe High School, Santa Fe Ford. This is Briarwood phases 1 and 2. This is Oak Ridge at High Springs. And so you can see that that logical pattern of development that has been already approved here is surrounded by other urban type development that is occurring. While we will have commercial stores in here, pedestrianism, bicycle racks and bicycle parking spaces, as well as protected walkways like you have at Publix, will be incorporated in here. And we are doing a landscaping program in here that is very robust. A first in here is, while I told you about having the connection from the neighborhood into the commercial area and having the external connectivity for the future connections as these properties continue to develop over time, we are one of the first projects that will put in the conversion of the rail trail that is here to create a multi-use trail there. Our office at NV5 is working with the city on a trails master plan. So a portion of this buffer area here will contain a future community rail trail that at some time, I don't know if it's in my lifetime or our children's, but you could potentially ride a bike from downtown Alachua along the abandoned rail line to High Springs. And we've reserved areas in projects that we have between High Springs and Newberry in the Norfleet project, by example, that will connect up. So we are planning forward for multimodal connections that then again tie into our sidewalks and our neighborhood and non-residential area to have a holistic multimodal and master plan community. If you'd like, Mr. Butts could reiterate his geotechnical information, or if he would take the podium and say, I would incorporate this material as previously stated, you could have him say it all again, or he can incorporate it by reference if that would be acceptable to you all as the board and the attorneys.
I believe you could incorporate it by reference if everyone's agreeable.
Okay. Thank you. We'll keep the train rolling. We talked about the future transportation circulation map, and what is important in here was while the city has one facility identified, we are actually building a portion of an interconnection here And we are, I believe, the first development that is working with the Florida Department of Transportation to address transportation system management throughout the city by studying all the traffic lights to look at synchronization and interconnection of the traffic lights to address the level of service here. This project proposes signalization, as I showed you, at that location, coordinated with Briarwood Town Center, and we have worked with Lake City DOT and Tallahassee DOT to coordinate that effort along US 441 highway. Staff has conducted the public facilities impact analysis. The analysis, Carson will tell you during his presentation, has been adequately addressed. We are compliant with the land development regulations. So last item, when we were talking about the comprehensive plan and the small scale map amendment, I kept reiterating, we're consistent with 29 goals, objectives, and policies effectively in the comprehensive plan. We are consistent with Article 2 and specifically Section 242 about site-specific amendments to the zoning atlas, and then Parent E1, competent substantial evidence provided. We have provided resumes for our professional engineers. We have about a half dozen professional engineers that are working on this. We have professional planners that are working on this. We have architects that are working, and these individuals are licensed to practice in the state of Florida and have worked to assemble this presentation and this plan. This is consistent with Section 2.43, Parent D, Parent 2, Plan Development Standards, as well as Article 3, Zone Districts, Section 362, General Standards, and also Parent A for Development Parameters. Section 3.6.3, Additional Standards for PD Districts. We have two that we are consistent with because we now, instead of having just the PD-COM, or just the PDR, it's late, we have a PD-COM at the north, a master planned commercial area that is interlinked to a PDR, which was the existing approval, and so we have both in a master plan community. Your professional staff and the departments at the City of Alachua have reviewed this application. We have been in this process since Halloween. I remember very intently our project team leaders saying this application is going in before November, and like, yes, sir, we're going to be in on Halloween. So for the months of November, December, January, February, March, we are here now with an application that meets the criteria of the city's comprehensive plan and land development code. They have reviewed the application. They have recommended their professional advice to you with competent substantial evidence that this is consistent with both the City of Alachua's comprehensive plan and land development code, and are requesting approval of this request. We are happy to answer any questions, and I was hopefully going to get through that quickly enough. So, yeah, Clay?
I have a quick question. Either one of you could answer. The two entrances not at the signal, will they be right turn only? They're probably required by FDOT.
That's a great question. They will probably be right in, right outs. FDOT is working very diligently on maintaining throughput on the highways. We will probably not have full access median cuts. That will be finalized during the development plan approval. And you know the slide that we showed that had the process. When we go through with the development site plan process, we will similarly have a pre-application meeting. We will have neighborhood workshops that will come back. DOT will probably make those others right in, right out, or RIROs, because we are having a full access point that will be signalized, controlled with pedestrian and all movements there. But yeah, the other two will probably be right in, right outs. Yeah, and they're closing a lot of medians all over the state.
And I would suggest it if they're not required by FDOT that you just go ahead and do.
Mm-hmm.
Just safety.
Well,
people turning left on to a 4-lane highway.
Yeah,
not safe.
I can opine as a planner through the 90s and 2000s when they built 39th Avenue. You all have driven down the Bacon Strip of 39th Avenue, and I looked in like every quarter mile there was a median cut. Well, now that businesses are developing there, the University of Florida Health and Santa Fe, healthcare and all, they're going back and closing them because they want less turning movements to keep the throughput working. So that'll probably be an eventuality. Yes.
Mr. Chair, just one thing I neglected to mention in my portion of the presentation, and I know Jerry alluded to it, and we discussed it a lot with you all during the land use piece, but and it actually is indicated in page 6 of the city staff report. But there is a substantial decrease in residential units and non-residential permitted square footage as a part of this PD. Essentially going from 686 potential units, whether they're multifamily or single family, down to 203 single family, very specified in the PD, and then a reduction of 267,433 square feet of non-residential. That's based on your staff analysis. That's above the 454,000 square foot that's proposed.
Yeah. Yeah. So everything that we stated during the land use is now being locked down by the zoning. I've seen the assertions or the specious arguments out there that this is half a Butler Plaza. I was the planner and still am the planner on Butler. I did that project on 267 acres in the city of Gainesville. So I know that to be not factual. Yes.
Thank you. Is there anyone that wishes to be an affected party? Go ahead, Carson.
Chair, before we go into affected party status, due to the time, it might be pertinent to extend the meeting past 11 p.m. Staff would rather get this all done tonight rather than have to reconvene in May. Right now, there's nothing else scheduled for the May hearing, so if we can keep it that way.
Very good. Board members, would you like to make a motion to extend the meeting?
Mr. Chair, I move to extend the meeting to 11:30, hopefully. No more than that.
Second.
It's been moved and seconded. All in favor?
Aye. Aye.
Anyone requesting to be an affected party? Please come forward and state your reason for.
My name's Finton Vargas. Finton, not Vincent.
Okay.
Finton. And I live on 188th Street, 15302, 188th Street. It's not directly adjacent, but it does affect me because that's my only way to get out to 441 and the rest of the world.
Okay. They are stating there will be nothing but an emergency exit onto 188th.
Right.
So there should not be any through traffic for this development.
There is.
On 188th?
On 188th, yeah. That was something that we discussed 5 years ago. There's through traffic through there. Whether they're getting into their community or not, they're going to that property on 188th Street. If they're coming in from the back roads and that one dog leg.
Okay. Okay. Okay, as an affected party, would you like to ask questions? What
Yes.
is your...
I have several questions. So now would be that time?
Yes.
All right. What specific provisions of the city's comprehensive plan support increasing commercial land beyond the original approved ratio? What changed since the original approval that justifies the increase? Would approving this set a precedent for similar upzoning requests elsewhere in the city? Has the applicant demonstrated a hardship, or is this purely market-driven request? Has a new traffic impact analysis been conducted reflecting the increased commercial intensity? Kind of get some of those answers. And who bears the cost of any required roadway, signalization, or infrastructure upgrades? How will increased commercial traffic affect nearby residential streets? What buffers, setbacks, or design standards are being enhanced to mitigate impacts? Will building height, lighting, or noise levels increase beyond what was originally approved? Is there existing vacant or underutilized commercial property within the city that could absorb this demand anywhere else? Will additional commercial development increase stormwater runoff? And has the drainage plan been updated? Are there impacts to wetlands, tree canopy, or conservation areas beyond original scope? How will noise, light pollution, and hours of operation be controlled? Does this qualify as a substantial deviation requiring a higher level of review or reapproval? And what mechanisms ensure compliance if the developer exceeds approved limits? Those are my questions.
Do you have a statement also, or?
Yes, I've been in real estate for 24 years, 12 of those years in residential and 12 in commercial. So I understand the need for development and growth. But just like Mr. Hartley said in the Terra meeting, we have to do this responsibly. We have to look at this pragmatically and understand the impact that it'll have, not just for us and our pockets, but for our children and their water, and our community. We can't just, bend over for whenever somebody says, hey, railroad, steamroll, bulldoze this through, like we've seen in both of our small towns, High Springs and Alachua. It's suburban sprawl that has affected. I saw not one but 4 wood storks on the side of the road. That's a highly endangered species. To see one of them is great. To see 4 of them on the side of the road means they've been displaced. We can't allow this to keep happening. Please vote your conscience.
We're going to give the applicant some time to formulate their answers, and then if Carson, if you want to, are you ready?
You ready? I think I got all 15 of his
Okay.
questions that he brought forward. Clay, help me out if I miss anything. I'm not going to address them in order because I think there's a certain logic to addressing these in a hierarchical format. Question number 14, I believe, was, is this a substantial deviation? Well, this is not a development of regional impact, and so a substantial deviation is an element similar to a notice of proposed change that happens to a different type of development order granted in the state of Florida and a municipality. So that question isn't applicable to a rezoning. What mechanisms are there to ensure compliance? Well, as we told, this is question 15, as we told you during the land use component, this would be inextricably tied by ordinance to a zoning ordinance. That zoning ordinance becomes effectively the law of the land, just like the city has a land development code, land development regulations, and a comprehensive plan. The document that is created here becomes the law for this property. If there is non-compliance with that, then the tenant or the homeowner is in violation of city codes, and that is the mechanism for addressing that. Question 12 had to do with the environment, wetlands, trees, and floodplain, and the system out there. There are no wetlands on the property. There are no known floodplains on the property, and the property is largely a tree farm, a commercial tree farm, and there are some existing businesses like Florida Road Rangers and Jack's Small Engine Repair that are out there. So we are unaware of any environmental circumstances that would require further analysis on here. Question 8 dealt with buffers, and all that was conveyed in the original PDR to the residents, like Mr. Pappas and others, that is all being maintained in there. So buffers around the perimeter of the property, buffers along the west side, buffers in the south, they're all staying the same. We're not changing those because those covenants were made by Clay and Sergio before, and those are going to stay. Who will bear the costs of roadways and things of that nature? The answer to that question is the developer. The developer builds those items, whether they be water lines, sewer lines, lift stations, roads, sidewalks, lighting, landscaping, and then the majority of those items are conveyed over in the form of right-of-way to the city, so the cost is not borne by the residents of the community. It's borne by the developer who builds that infrastructure, is certified and guaranteed to the city, and then the city takes possession of that because it is built to city standards. Was there a new traffic impact analysis for that? Yes, you've seen that both in the comprehensive plan slide deck as well as here. There was a specific analysis that looked at the net change in the land uses, and that's how we came up with the specific numbers that were testified to during this rezoning and then offered also during the comprehensive plan amendment. The question of a hardship is not relevant to a rezoning. We are not asking for a variance or a waiver. We are coming forward with a development program that has specific conditions consistent with the comprehensive plan and land development regulations. So we're not talking about a hardship here. So that really doesn't play into the PDR or the PDCOM. The question of whether, and I understand this one, whether or not this sets a precedent or not, it absolutely does not set a precedent. Every time an individual, whether they have 0.25 acres or 1,000 acres, want to make a change to the comprehensive plan, the future land use map, the zoning atlas, or any preliminary plat or element like that, or an approved final development plan, they must go through this process. We are not creating a domino effect where the next person will have it that much easier. They will have to do similarly a pre-application meeting, neighborhood engagement, neighborhood workshop, file an application, work with staff and get an approval and get before you. So a precedent is not set that makes future projects easier. I think it gets a little tougher because I would like to think that Clay and I keep raising the bar. The next is talking about commercial runoff and the stormwater management facility for commercial. The systems that are designed in this project, I don't know if Sergio is still there, are extremely large, shallow type basins that cover large land areas. We believe from our preliminary engineering, from the geotech that we've conducted, that we have more than adequate space, and actually it's possible that those basins could get smaller. And so they will be landscaped with thirsty plant material around them to help them function well. They are designed as dry basins, not wet basins, so that helps. Height, noise, and light. That is a component of the city's land development regulations. So those businesses will operate similar to other businesses in the community. If there are professional offices in there, they may be an 8 to 5 if it's a bank or a dentist office or doctor's office or something like that. If it's retail or dining, it may go later into the evening, but they will operate as standard procedure for other businesses in the city of Alachua. There was a question about number 10, I believe, existing vacant commercial. Almost every community that I work in, and I think that you work in, always has that question. Is there a parcel somewhere else where you could do this that's vacant? Well, the answer to that question in this scenario is no. There's not another parcel that our applicant, Mr. Lerner, and Florida Road Rangers own that we can go say, we want to do our project on your land. That's a germane question if you're saying, well, I want to build a new skate station and then there's an empty gymnasium next door. But here we are modifying an existing development plan. So we can't compare another piece of property to this because this is the application that's before you for this very project to sit upon land that's already containing, and I will use the word again because Madam Highlander did not misstate that. Entitlement does not mean I am due something. Entitlement, when Clay and I speak of that as professional AICP planners, 4 units an acre, 5 units an acre, 20 units an acre for multifamily, that is a term of art in the planning lexicon. And entitlement means that is the vested right that that land has for that person who owns that land. So we're not talking about, a gift. We're not talking about we're entitled this. We're talking about what it physically is numerically. And what specific provisions? The first question. The provisions that govern this property will be tied to the zoning master plan as well to the ordinance that the city commission adopts as law for this land. And number 2, the question was, what changed over time? I can't answer that as well as Clay, but I can, from our work with the team, and Clay can certainly fill in any gaps, the desire to create a better project. That's what changed. as opposed to leaving a little strip of community commercial along the frontage of 441 that could turn into maybe a couple shops or a strip development, versus the chance to really create a mixed use community that has jobs at all different levels, that is multimodal in nature, that is interconnected, with trails and a coordinated signal. That's what changed. They want to do a better project. What did I miss?
No, I agree, and I think what has changed as well is the recommendation on the future land use map, and that this project will be at a more appropriate and a lower density and intensity and a master plan, and so that is a change condition.
Yeah, it's rarely do you see people that are coming forward that say, we actually want to do less than what was out there, and that's what this does.
Okay, thank you. Sir, do you have any rebuttal?
Hopefully I got them all. I'm impressed. Try not to miss any.
With the change in number of homes, my question is, it was 250, so 275, it went down to 203. Now the commercial, will that have residential in it? Will it have an apartment building?
No,
So what was the additional 400 and something, please?
So the PD proposal would not include any residential units in that PD com. So that reduction of 483 is the removal of that. So the only thing on the PD that could be done are the 203 single family detached units.
And those single family units are staying the same size? It's all the lots same?
Yes, the PD plan would retain all those minimum lot sizes that were agreed upon before.
And the natural buffer zones, would those remain the same as well?
Yes. Yes, sir.
Thank you. Anyone else want to be an affected party?
Yes. My name is Gary Pappas. I live at 16104 Northwest 188th Street, which is directly across from the entrance to the existing tree farm and directly across from the proposed emergency entrance and exit from the tree farm. So that's where I live. I think I'm clearly an affected party.
Okay, so you feel like the traffic will affect you?
Well, since none,
additional traffic on 188.
As Finn mentioned, and again, none of you were there back in 2021 and 2022 when we all participated in the community meetings with the developer and ownership about the traffic flow on 188th, escaping the traffic off 441 and cutting through the back roads to get either to 173rd or beyond through the back road. So 188th gets a tremendous amount of traffic off 441, just like the new road that was constructed through the Wawa. So those of you who travel west on 441, like I do, especially in the morning, will see a backlog of cars trying to turn into the new Wawa shopping center on that little perimeter road that they created to avoid 441. So yes, 188th Street has a tremendous amount of impact off of 441. And so anyway, I'll stop there. Will you allow me to be affected party status? Or
Sure.
Okay. I do only have one or two specific questions, but I would just like to make some comments to build up to those questions if I may. And I will keep them short. I was heavily involved in this project from day one. Mr. Swager and Sergio and the tree farm ownership were fantastic partners with us when we developed, because it was a community effort, the initial plan. And as Clay, I'm sorry to say Clay all the time. I apologize to you all, but it just seems more natural to me. Mr. Swager, I appreciated reiterating that the agreements we had, that the entrance would only be an emergency entrance off 188th. Some of the other agreements we had was that there would be no construction entrance off of 188th, that there would be no construction staging on 188th. These were all things that we reached agreements on in the first time around. And I'm glad to hear they're still the same here today. What Mr. Dellenbach just said, very rarely does someone come to you and say they're doing less. That's not true at all. They're building a 400,000 square foot shopping mall. All right. And so this notion that, oh, we're getting rid of the community commercial to make this better. Well, what's better is a shopping mall. And you've heard discussion here today that this is going to be a town center or a city center. Their own application says it's a shopping mall with 8 out parcels and 3 big box stores. You saw them on the diagram. This isn't, there aren't going to be doctors and veterinarians working here. Their diagram showed retail. That one big box store is big enough for a Walmart. There's already talk out in the web that that's what it's going to be. I know the city already approved a Walmart 10 years ago
Mr.
for
Chair, we can't talk about specific end users. It's illegal.
Yeah,
Can't do it.
the end user does not
it's big enough
matter.
for a Walmart.
But
It is a shopping center. Their own application sets out what the uses will be in the 8 out parcels and in the big shopping mall. This is not going to be, and I would, in my affected party status, I would encourage you to see if the ownership or their developers will explain to you how there is going to be doctors' offices and veterinary offices in 2 big box stores. And we know it's not going to be doctors' offices and veterinary offices in the out parcels because their own application said 3 sit-down restaurants, 3 more fast food restaurants, in addition to the Chipotle that we already heard about today, a coffee shop with a drive-through, a gas station, and an auto service center. This is going to, and there was discussion about how we're going to pull all these people in and limit traffic on 441. What we are going to do by building this is pull people off I-75 and pull people off 441, all the commuters, to come to a shopping mall on the outskirts of town. And this is not going to be something where people are going to be living and going and working. These are quarter-acre lots. These aren't starter homes. This was supposed to be an upscale development. So the notion that someone who's going to buy a 10,000 square foot home is going to be working at a gas station or a restaurant is kind of silly. It's a shopping mall. That's what it is. That's what they want it to be. And that's what you should all, take into consideration when you're addressing this. And I know that DOT controls the traffic and there's tremendous amount of work to their credit that has been done on traffic. But traffic is going to be absolutely insane on that street. And yes, traffic may slow down a little bit in front of 188th Street because there's a light. But the amount of traffic that's going to be flowing in and out of a shopping mall plus 200 houses, not counting the fact that you already approved a massive commercial development of Briarwood on the other side of 441. So all of the discussion we heard tonight, throughout the night, about the traffic on 441, I give ownership and their consultants a tremendous amount of credit for doing the work and trying to present a plan that sounds palatable. But the notion that DOT's evidence of trips says that trips are down on 441 is just ridiculous. They don't live here. The traffic on 441 is getting worse and worse and worse. And it's just going to get worse now with a shopping center and a town hall across the street. And I know that's all generic stuff that you've heard all night long, but please, please, as our Board of Planning and Zoning, who are the initial gatekeepers for these projects, please take that into consideration as you view this request and more and more and more that will be coming down 441 towards High Springs. It's just going to keep continuing. When is enough growth enough? The one question I would like to ask for clarification, and I think this is to you, Jerry. Mr. D. Mr. D. There was a mention of a signage variance, my word, not yours. You said you said the big box, you didn't use big box, my words. The big box stores are going to be set back behind the out parcels on 188th, on 441. I think you said they're going to be a quarter acre back. Your diagram said an eighth acre back, an eighth of a mile back, not a quarter of a mile back. I just want to understand, does this application that the board may be approving tonight include some sort of variance, my word, for signage? Thank you very much for my time, for hearing me several times tonight. Thank you for the good work that you do for this community. I hope that everything these folks say will happen with traffic and safety will happen. I hope they will. I fear they won't.
Thank you.
If it pleases the chair, staff would like to go over the 4 proposed deviations requested by the applicant.
Please proceed.
Yes. So table 3.6-3 of the city's LDRs permits certain deviations in a PD com from the standards of the LDRs, assuming that those development standards shall only be modified in ways that are consistent with the general intent and purpose for the PD com district. I'll go out of order to address Mr. Pappas's question first. Section 6.5.4 C3C establishes the standards for multi-tenant wall signs. Specifically, the existing standard states, in the case of multi-tenant buildings, each occupant of the multi-tenant building shall be permitted wall signage for the portion of the building elevation which is included as part of the occupant's premises. Such signage shall be subject to the maximum sign area provisions established in section 6.5.4 C3B. The existing maximum signage is 10% of the building's front facade, or the facade that the sign is located on, I should say, up to 350 square feet for the entire building. The key thing here is, with multi-tenant buildings, that 10% is calculated for the individual portion of that structure that is the tenant, and then the whole building under our code is still limited to the 350 square feet. The proposed deviation by the applicant would maintain the 10%, but the 350 square feet only for multi-tenants would not be capped for the entire building, instead being capped per tenant. So it would act more as the single tenant wall signage code does. Does that answer your question, Mr. Pappas?
Yes, thank you.
Okay. Going on to the other 3 deviations, which are relatively minor in staff's view. The first 2 are in the parking standards. Table 6.1-1, minimum off-street parking standards, establishes a sliding scale for sales establishments when it comes to a parking standard. For any sales establishment 300,000 square feet or less, the standard is 1 space per 305 square feet in floor area. The standard then changes as you go up in size. The applicant is proposing to just have the 1 space per 305 square feet flat, regardless of size of the retail sales establishment. That would still keep the 125% maximum requirement. That is more for consistency across the whole site, so you don't have different end users with different, varying degree there. And of course, well, the applicant can speak to why they proposed these. I'm just going through what they are. Section 6.1.4 D1 is the second deviation in parking, and that's bicycle parking. The deviation would be from the current standard, which is for any parking lot with over 50 spaces of off-street parking, there's a required rate of 1 bicycle parking space per 10 vehicle parking spaces. So any parking lot under 50 spaces, which could be out parcel lots, for example, wouldn't be required to have bicycle parking. The proposed deviation would be a minimum of 2 bicycle parking spaces, regardless of the size of the parking lot, regardless of the size of the use. And then from there, it would scale not based on the parking lot size, but based on the square footage of the user. and that would be 1 bicycle parking space per 5,000 square feet. And then the last one is in landscaping, section 6.2.2 D3, perimeter buffers. Specifically, instead of the internal buffers with the out parcels being established by table 6.2-2, they would be standardized between the out parcels as 5-foot landscape buffer strips to keep that landscaping more consistent between the end users in those areas. Again, the applicant can speak to the justification for those. Just wanted to make sure those were standardized in the record.
Thank you. Do you want to answer?
I do. You don't have to for my behalf.
No, I'm just happy we're getting on a first name basis because Mr. Diedenbach enjoys. Mr. Pappas has been very kind, and it's been a pleasure to work with him because I always get a kick out of working with attorneys as attorneys know. It's fun. I find other people that are as analytical as I, a pleasant surprise in today's world. He talked about no construction on 188th, no construction staging on 188th, as Clay said. All that covenant that was made stands there. I am going to differ from my newly made friend here. I leaned back as he was presenting his questions, and I asked our client, would you not lease to a doctor, Aspen Dental, an optometrist, a professional pharmaceutical compounding center? And they're like, of course we would. So it is not a fallacy or imaginary that we would have medical in there. That happens. There was a comment about the notion of this being evidence and it's going to be worse. We didn't make up FDOT's numbers, for the record. The numbers that we presented there, and when Carson produced the city's concurrency standards, Carson and Brian spoke with Clay and I on the phone. They're like, you're going to like to hear this because the volume of traffic in Section 7 went down by 1,000 trips. That's FDOT themselves going out, laying the rubber strips out there and counting. So Section 7 went down by 1,000 and Section 6 went down by 1,500. Those are the factual pieces of information taken directly from the Florida Department of Transportation website last week and throughout the weekend as we prepared these presentations. So those are fact-based elements that go into the traffic impact analysis. And as far as the signage, when you're designing a project of this size and scale, and you've got inline tenants, you've got out parcels, you want to have consistency. The city's code doesn't anticipate everything. And when we sat down, there were, Carson, if you can perhaps remember, we had hundreds of bicycle parking spaces required. And so to create a better design, realizing that, okay, I'll use the previous analogy. If you're the bus boy or the bus girl or the host or hostess, and you want to ride your bike from the neighborhood here, you don't need to have 50 bike spaces to clutter up the pedestrian realm. So we're asking for more uniformity. And similarly, on the landscaping, and you heard the 5-foot buffers, that is not the external portion of the project, that's internal. So if on an out parcel, you get a restaurant on one, they're going to put a buffer around their perimeter parking that interconnects. The next person has to match that buffer. So you have continuity of design in between your out parcels, down your roadways and stuff like that. So that's why we asked for that thing. And there was a really important question that the retired attorney, Mr. Pappas, had, are we getting a waiver or a variance? The answer to that question is no. You all know this, and I know that our attorneys and planning staff know this. When you're writing a plan development, this isn't a waiver or a variance. It is writing effectively the law for this specific parcel. So it doesn't set a precedent elsewhere. It is designed specifically to function inside the parameters of this land and this use. Good question.
Thank you, sir. Do you have any rebuttal?
No, sir. No, thank you.
Thank you. Any other persons that wish to be an affected party?
Michael Owen, I live in the neighborhood there. I access my house through 188th Street, so I'm definitely affected.
Okay.
All right. The when it was going to be the housing, like it was approved, there's going to be housing there. I was going to have more neighbors there. Yes, there's more cars that are there, but when you put a commercial and make the commercial bigger, there's going to be a lot more cars. Now they want bigger signs to bring more people in there. So here's my question. How do we know that they will actually even build homes there? Is this just a setup so they can get the stores in? I don't know that. I'm not saying that. I'm just saying, how do we know? We don't, do we? Because they ask permission for homes. They don't have to build homes, do they? I'm asking you a question.
They are obligated to put forth that construction plan.
Right.
And if the market stops, well, construction stops.
Right.
But
we understand
as a
that.
general rule, when they put forth that construction plan, they have a certain amount of time to do it,
right?
Or that goes away.
Okay, but if they build the commercial stores and then they don't build the houses, so that then the permits for the houses go away, basically. But the stores are already there, right? I'm just trying to. I'm looking at what could happen. I'm not saying
Yeah,
it would be there. You wouldn't make them take them down; they'd still be there, right? Just a question.
Yes.
Okay, thank you. The emergency access road. How do you make that an emergency access road so nobody else uses it? That's a good question. I'd like to have an answer to.
Absolutely. Mr. Chair, there would be a gate at that entrance off of 188th Street. The only police or fire would have a code to utilize the gate. So no regular vehicular traffic could get through.
Perfect. Thank you. That's a big question, because you can say don't enter, but people will still go.
Right.
So, all right. The other thing is, why are there 3 entrances to 441? That brings a lot more traffic and traffic problems for all the traffic there. You got a light there. Why we have 2 more entrances? And then you said that also that they mirror Briarwood or whatever the name of the thing is across the street, that they all match. And then you say that there won't be a connection through the medium to them, but there's going to be entrances on both sides, 3 of them, all lined up. So you would think there would be a cut through the medium if they're doing that.
That's got to be done. If you have more questions, let's get all your questions,
okay.
and
then the other thing is that who owns the corner lot there on 441 and 188? Is that their lot? Is it is it someone else, other company, or what? Because they have a road going to that lot in the plan, and they also on the other side they have 3 roads going to that property over there. Is that more of their property too? So waste of money to build roads extending out to the edge of the property is another question. That's all.
Okay, he's taking down all your questions. So
and the other question is, we got professional planners here. Why didn't they professionally plan it the first time instead of doing it twice and waste all our time? Thank you.
Thank you.
I'll take the last one first. Planning is dynamic. Cities are dynamic places. And as growth and change occurs and trends and consumer demand for housing, consumer demand for retail changes, it's far better to change it when you're on paper than when you're out there and you're a development that's built and you got to dig things up. And so I applaud Clay and Sergio and Mr. Lerner and others for having the foresight before this actually started to go into infrastructure development, meaning water, sewer, electric, fiber, lift stations, and so forth, recognizing this and coming to ask you respectfully to amend the plan to do something better. Who owns the corner? I don't know. It has commercial land use and commercial intensive zoning on it. It's not a part of this plan. And it's that 900-ish foot stretch from 188th. The 3 entrances and why, I believe the question was asked and answered. somewhat by the chair. The Florida Department of Transportation, who has jurisdictional control over US Highway 441, has access management criteria. You don't, or you wouldn't cut the medians multiple times to create an uncertainty rather than have a hierarchical approach to, if I'm a pedestrian or I'm a cyclist and I'm in Briarwood Town Center, or I'm going to go babysit some kids in the other neighborhood or something like that, you want to know where to go. So you want to do that at the safest point of connection. So in answer previously, the others will probably be right in, right out, primarily for vehicles. You know, obviously the residents of the neighborhood, they can turn in without a traffic light and bypass the non-residential and go straight to the neighborhood, or stop and get food and go home. The far easterly one, as a right in, right out, it serves as a valve to get out of the project and continue down 441. The responsive retail and commercial development often relies on passerby traffic, as we call it in the industry. There are already trips out there today. One way I like to think of things as a professional planner is, if you build a Burger King, it doesn't generate new trips on the road because hopefully nobody lives in the Burger King. It's building and it's relying on the passerby traffic that's out there. Sure, folks from this neighborhood that Clay and Sergio are doing will eat, shop, may work there, and may, you know, be part of the construction team. Who knows? But you build that connectivity, to answer the other question that was in there, to the west, to that 900 feet of parcels there. You build 3 accesses out to the east because the city's comprehensive plan, much like the counties and the city of Gainesville and the city of Newberry's, demands interconnectivity. If you don't have that interconnectivity built in from the point when you place land use and zoning on the property, you rarely get it. So that is the foresight of transportation system and demand management, saying we're going to have an interconnected city. And I could show you pictures of, or you could imagine, you know, somewhere out in a rural area where you got cul-de-sac neighborhoods, the only way for the kid to get to the park is to do that. But when you build an interconnected neighborhood, you
Stop
can
you one
loop.
second.
Oh, shoot. Hey,
Board members, we need to extend our meeting.
15 more minutes. I'll shut up.
Mr. Chair, move to extend 11:45 because I know we've still got some other citizens that had commented earlier. Thank you.
Second.
Been moved and seconded. All in favor? Aye.
Aye.
All right.
I'm done.
You done? Sir, do you have any rebuttal? Okay. Any other persons wanting to be an affected party? All right. Mr. Carson?
15 minutes of counting.
We'll try to go as fast as I can, Mr. Chair. Good evening again, board members. Carson J. Crockett for the record. I already incorporated my previous presentation into the record, but just to restate that here. If I could have my presentation on the screen, please. We'll skip through some of the overview, as I'm sure you are all very familiar with this project at this point, between the applicant's presentation, the affected parties, and the previous application here. So this is a 182-acre subject property out at generally 16650 Northwest US Highway 441. What I do want to note about the subject property is that currently approved PD master plan that was originally known as the Northwest 188th Street PD. This rezoning would amend that existing PD. The subject property also has that approved preliminary plat / final PD plan that's titled the Farmlands Preliminary Plat. This rezoning would require an amendment to the existing preliminary plat should the rezoning be approved. Of course, here we have the subject property, which we're all pretty familiar with. We have 441 and the subject property. That's approximately 182 acres here. In the black and white hatch border, it does share some borders with the city's municipal boundary. The existing zone districts on the site include community commercial, which permits up to 15 dwelling units an acre and mixed-use developments, and up to 1.25 floor area ratio for parcels 1 acre or less in size for mixed-use developments. And then the commercial intensive category, which permits up to 15 dwelling units an acre and permits up to 1.25 floor area ratio for parcels 1 acre or less in size in mixed-use developments. And then the existing planned development residential, which PDs are very specific in what their densities allow based on the PD ordinance. The Northwest 188th Street PD permits up to 275 dwelling units and 4,000 square feet of non-residential floor area. Again, that 4,000 is that amenity center recreation use. This is the existing official zoning atlas. The light pink is the residential PDR portion. The dark red, or the brighter red, I should say, is the commercial intensive portion. And the more pink salmonish color is the community commercial 441. And then, of course, 188th Street over here. And this is what the current approved PD master plan looks like, just for your reference. You can see that this U shape here maintains a lot of the existing approval, and it's really this portion up here that's being altered in a significant way. So those proposed zone districts are, of course, planned development residential and planned development commercial, which would be divided into 3 development areas. Development area A is approximately 48 acres in size and is the commercial area, which would have 0 dwelling units allowed, 0 dwelling units per acre, and would permit up to 450,000 square feet of non-residential floor area. Across those 48 acres, that would be approximately 0.22 floor area ratio. Development area B is the single-family residential area and is approximately 81 acres, which would permit up to 203 dwelling units. Across those 81 acres, that would result in about 2.5 dwelling units per acre, with 0 square feet of non-residential permitted. And then development area C, which is generally the common area and open space, which is approximately 53 acres, would permit 0 dwelling units as well. And that's where that 4,000 square foot amenity center recreation use would be maintained. Of course, here is the proposed zoning atlas, where the lighter pinkish purple is still the PDR, and then those reds get turned into this brighter purple color, which would be the PD COM along 441. And this is what that proposed PD plan would look like. The one thing I want to note that we haven't really talked about, the 4,000 square feet of amenity center is actually limited to being in this central or a central facing open space. No intensive recreation use can be placed in this portion of the C area or this portion of the C area. They have to be set back a certain amount of feet. The 1/3 acre lots are highlighted in orange, and then the half-acre minimum lots are highlighted in yellow, and that helps that transition towards those more rural residential and agricultural areas, including with you have buffering, you have larger lots, buffering and open space, larger lots. So all in all, the net change in total, 203 dwelling units would be permitted, which is 483 less dwelling units than the current zone districts allow in total. And in total, 454,000 square feet of non-residential floor area would be permitted, which is over 250,000 square feet less than what the straight zone districts currently allow. Neighborhood meetings were held on September 24th, 2025 and October 22nd, 2025. We've gone over this. The neighborhood meeting summaries are available in the staff report. The application has been reviewed for consistency with the comprehensive plan. Staff found it to be consistent. That full evaluation is available in the staff report. The environmental conditions analysis is much as the same as it was for the small scale application. Again, there is that condition related to the high aquifer recharge area, and that would ensure that those additional reviews are completed before they even submit their final PD plans to us. That'll be a required portion of their submittals to us. So you'll see those before the site plans or final PD plans come back before you. Of course, the application has been reviewed for compliance with Section 2.4.2E1 of the city's land development regulations, which establishes the standards with which all site-specific amendments to the official zoning atlas must be found compliant. We'll briefly go through these in an effort of trying to save some time. Consistent with comprehensive plan, already discussed. Consistent with ordinances, we're currently going through whether it's consistent with the land development regulations or not. Logical development pattern. The proposed PD master plan locates those higher density uses along 441 and transitions those down. As I was describing when we were looking at the PD master plan, it places those buffer areas and larger lots in those transitional spaces to the more rural and agricultural areas, which would result in a logical development pattern. Premature development, the subject property is already designated with urban future land use designations, and it already has approved development rights, so this would not result in premature development. Incompatible with adjacent lands, going back to those buffer areas. And then also it's important to note that the PD-COM is a continuation of the commercial land uses that are commercial intensive to the east and west. And then the residential portions are, again, they have those buffers, and there's internal buffering as well between there to make sure everything's compatible. Adverse effect on local character. No adverse effect from excessive traffic, density, and/or intensities of use, building height and bulk, noise, lights, or other physical effects or nuisances are anticipated. And I want to stress here, because this is a reduction in the allowable densities and intensities, this application, this zoning would actually have the have the potential for a much lesser impact on the local character. Not deviate from pattern of development. The proposed PD master plan locates higher intensity. We've already gone over this. This is a pretty standard location of the higher intensity uses towards 441, stepping down towards those residential uses. It's very consistent with the pattern of development down 441, while making sure that that commercial area actually has space to breathe. Encourage sprawl. The companion application has been evaluated for sprawl, and staff found that it met 6 of the 8 urban form criteria established in Chapter 163 Florida statute, and therefore does not constitute urban sprawl. Spot zoning, that comes back again to those adjacent land uses that are related. This would not constitute spot zoning. Public facilities. The applicant has provided a PD utility plan as part of the PD master plan, and assurances for utility provisions are included in the draft PD ordinance and the draft PD agreement as required by the code. They are within the community potable water service area and the community wastewater service area, and as such would be required to connect at their cost. No adverse effect on the environment. As we've gone over, we've gone through the environmental impact or environmental conditions analysis. There are several conditions in the draft PD ordinance that relate to listed species surveys, that relate to the geotechnical impacts, wetlands, all of that, none of which are of general concern at this point in time, but those will all get reviewed in more detail before any final PD plan is approved. And then, of course, we have Section 3.6.2A1 of the city's land development regulations, which establishes the standards for with which all all PDs must be found compliant. This application has been found to comply with the standards of that section. We have Section 3.6.3A of the city's land development regulations, which establishes the standards specific to PDRs. And the application has been found to be consistent with that section. And then we have Section 3.6.3D of the city's land development regulations, which establishes the standards specific to PD comms, which staff has found it is consistent and compliant with that section as well. This slide goes over those deviations we've already discussed, so we'll just go right by that. The public facilities impact analysis. Staff conducted a public facilities impact analysis with the findings included in the staff report. A PD is a preliminary development order, and as such, concurrency will be reevaluated at time of a final development order. Staff notes only one potential deficiency on roadway segment 6, and this potential deficiency would need to be addressed prior to the issuance of a final development order. And I'm sure we're all familiar with segment 6 by this point in time, but it is the portion. The projectors want to go home. It's the portion of 441 west of Interstate 75, between 75 and County Road 235A, segment 6 there. That brings us to staff's recommendation in a much shorter time than my presentation was originally going to take. Staff recommends that the Planning and Zoning Board find the site-specific amendment to the official zoning atlas for AYLA LLC, First Coast Road Rangers LLC, Jack's Small Engine Repair LLC, and JTFA LLC to be consistent with the City of Alachua Comprehensive Plan and in compliance with the city's land development regulations, and transmit such finding to the City Commission with a recommendation to approve. Now, I know I went through that kind of fast given the time. If you have any specific questions on the staff report, I'm more than happy to answer those at this time.
Board, do you have any questions for? Public comment.
I have to swear in really quickly.
Do you swear or affirm the testimony you're about to give is the truth and nothing but the truth?
I do. Hello, sir. Story Lindbergh, gonna be fast. I move you reconsider your previous vote for the land use change on May 13th of last year when it was land use changes to the Tomoka Hills property. It was a 2-2 vote and it failed. Has anyone up here under the impression that you had to have a 3-1 vote? I know I'll talk about something else, but I am concerned that there was information shared that would tell you that you need a 3-1 vote. You can have a 2-2 vote. It's legal. Addressing Mr. Comments, thank you for reading my Facebook post. I take a lot of pride and integrity in sharing facts because people do not hear about these things, and I think the city likes it that way. It's late, I'm going to be very honest.
Mr. Chair, the witness needs to speak, or the public comment needs to pertain to the
This is about the motion,
application.
ma'am. So the
Well, we're going to avoid ad hominem
well,
tonight.
he made a comment that the 1 million is not half of Butler Plaza. I got that because on the Butler Plaza website it said 1.7 million of commercial square feet space. I feel like I'm touching a nerve, so maybe there's some truth to what I'm saying.
No, we're just trying to have you elicit facts.
This is public comment. I'm not presenting evidence as an affected party, so this is my public comment. This is public comment. I'm not an affected party.
The chair can still regulate the meeting.
We would like you to streamline your
Yes.
comments, please.
So my comment is very important because if the land use failed, a 2-2 is a fail, we've seen this in the past, then this one would be an automatic no. This happened on May 13th, 2025. I know you are a recommending body, but your recommendations are very important and very serious to the public and also to the commission. I appreciate your time. I know we're very tired, but if there's any communication that you cannot have a 2-2 vote, that you need a 3-1 vote, that is terrible. So I would like you to reconsider that or think that if that is something that happened. And I just wanted to clear my name because the applicant has stated many comments from my post, and everything that I said is based on the staff report. It's based on facts and it's based on the maximum intensity. And that's all I'll say about the rezone. Thank you.
Thank you. Any other public comment? All right. Board would like a motion, please.
No.
I move that based upon the competent substantial evidence, the presentation before this board, and staff's recommendation, this board finds the application for a site-specific amendment to the official zoning atlas for AYLA, First Coast Road Rangers, Jack Small Engine Repair, and JFTA to be consistent with the City of Alachua Comprehensive Plan and in compliance with the city's land development regulations, and transmit such findings to the City Commission with a recommendation to approve.
I'll second.
All right, it's been properly moved and seconded. We'll have a roll call vote. Ms. Highlander?
Aye.
Ms. Judd?
No.
Mr. Minadary?
Aye.
Chair votes aye. Motion passes. All right, I don't see anything else on the agenda.
Mr. Chair, if I can just have 1 minute, please.
Yes.
Under board comments. I apologize. I'm going to distribute something very quickly to my fellow members of the board. And I think I have enough to go all the way down. And like I said, I'll get this done in a minute. Recently, I learned that there is a offering for a high megawatt data center development site at 12705 Northwest US 441. I don't think it's a new listing anyway. The listing goes on to talk about it being 104 acres, that it has the right scale, infrastructure, profile, etc., for a modern hyperscale AI. And that is immediately adjacent to the tech center, to the fire station, that whole cluster of development on that side. Briefly, and again, I'll get all this done in a minute. Briefly, it goes on to talk about the fact that there's significant power demand there, since it is adjacent to a substation access with 168 kV transmission lines, which are huge, has three-phase power, natural gas service. Again, it says it's GRU Electric, City of Alachua Sewer. I don't know what the water is. I'm guessing maybe it's above ground or has wells, and it's also it is the old site of the Alachua battery plant from the 60s, which at that time that area was very rural. I would have concerns as a citizen, as far as that location. I did talk to our planning team as well as the counties. Neither one of the jurisdictions have anything in the comp plan or land development codes that would guide the development of a data center if it were to come to our community. And the advertisement goes on to indicate to the reader that it has the proper zoning, etc. And it also indicates that it reduces your entitlement risk, since it has a clear path forward for development as opposed to a commercial zone designation. So I say all that to say this particular property is in the unincorporated area. It's always likely going to be that way given the prior use. The city of Alachua never, in my history, had a desire to annex that land because of its previous use. I have significant concerns that this community is not prepared for something like that if it should come forward. It's a free market. And my concern is that it's being marketed as ready to go, correct zoning. My conversation via email with the county is that's not the case. So in any event, I think that this topic should be part of the discussion that this board has moving forward with the city commission, because we don't have that, what I'm saying, and we're looking at our comp plan and the long range plan. And the only other thing I would say with regards to my opinion as a citizen, not speaking on behalf of the plan board, I continue to become or am concerned with the rate of development that I see in this community. I've mentioned it on several occasions that I don't think the proper infrastructure planning and long range vision is correct for this community. Again, I am an advisory person, and I understand that I'm not speaking on behalf of the plan board. I look at our logo and see what it represents, and I feel like we're moving away from the division of having like a rural agriculture feel. And I don't think that we want to be a bedroom of Gainesville. But again, I'm not an elected official. I don't set those parameters. I don't set those message. But I would hope, given what's happened over the last couple of years, that our city commission will rethink what that vision is, which will be part and parcel, as I understand, the major item for our meeting coming up in the next week. And I hope that they'll rethink of what that vision should be and where we should go forward from this time. And again, I'm just speaking as a citizen, not on behalf of the plan board. Thank you, Mr. Chair.
Thank you. Any other comments from anyone on the board? You have anything?
Mr. Chair, I just want to make sure you take public comment before you adjourn.
Any other public comments?
Good evening again, Brian Bisher. Thank you, Board Member Judd, for that. That property actually came up on my radar as an issue, and specifically related to things like data centers. And so I think next week you guys are going to have your meeting with the City Commission, and that's relative to the comprehensive plan. And I think there's been a clear mandate from the voters in this city that growth is an issue, and the way growth has been happening is an issue. And so you have to think about, what is this going to look like in the future? Are you just going to continue to rubber stamp everything that comes before you? Most of the things that come before you are developer driven. So the developer always has a good idea when it's relative to their property. And rarely do the negative impacts come to light. In fact, I would say they're not even mitigated, they're minimized. And so you're not necessarily, planning in the sense of planning as much as you are approving or recommending to the city commission. So I would encourage you to think about what's going to happen next week. And I want you to be able to think about what your vision for this city really is, because that's what you're going to be talking about. If you just show up next week and listen to what the staff have in mind or what they've recommended, they are basically shown that they're advocates for development, and that's going to be their recommendations. And so you have to think, okay, is that really what the citizens want? I'm telling you, it's not. When you think about the comprehensive plan and you think about things relative to, say, data centers and how they're going to utilize your electricity resources and how they're going to use your water resources, what are you going to do in order to minimize the impacts of those types of industries, right? Are you going to require that they used X amount of reclaimed water? And it should be a high percentage. Otherwise, it's just going to be sucking it out of the aquifer, and we don't have enough. I think that's been really clear, especially with this drought, that we don't have enough. I dove Mill Creek Sink this last week. It's down 8 inches in the last 2 months. Never seen it that low, ever. It's not flowing, right? When springs don't flow, they die. When they die, rivers die, right? And this Good Life community, I'm glad you pointed that out. 3 of those things are relative to environment, right? One of them's industry. None of them is many, many thousands of houses. Thank you.
Thank you.
Hello, Story Lindbergh. I just wanted to smooth that out. I didn't really appreciate being cross-examined during public comment. I was not accusing anyone of anything. I was vaguely sharing that I hope if you have nothing to hide, you can say you did not receive any communication from an attorney associated with the city to tell you the ratio of your voting. That is a concern. And I just wanted to share that. And I look forward to a productive discussion next week when you're with the commission. I'm protecting my source and everything else. So thank you. Good night.
Any other public comment? You are.
Just to respond to that, I did not receive anything from anyone. I did not know about that until you shared it. So can't speak for my other board members, but no, the answer is no.
And I would just add, I almost said something earlier, but I stopped myself since we're under comment. Absolutely not. I haven't had any communication with anybody about any of these items, period.
All right, members, can I get a motion to adjourn?
Move to adjourn.
Second.
Been moved and seconded. All in favor? Aye.
Aye.
This meeting is adjourned.